welcome to Requiro. Today we are going to be talking about updates in Luigi Mangione's case. Finally, about time, you guys are probably thinking. I've been busy, okay? I've been playing catch up on a lot of the documents since December last year and everything else going on in my life. So in this video we are just going to be covering the updates from December 2025 all the way up to January 2026, because I think that will be a lot better for me to tackle 2 months at a time in one video instead of 4 months in one video. So my next video I'll be covering over the updates in February and also March in my next video, and there were updates happening in Luigi Mangione's case even when the December suppression hearings were happening. Now, you guys probably notice I'm in a different location and I'm talking a little bit more quietly because one, where I normally film is upstairs where I'm staying. There is a painter here and there is big windows. I like big windows, we get great lighting, but I don't like when there's a painter around there and they can see me, and I'm very subconscious still when I make these videos, and I am downstairs in a different room where the wallpaper is amazing, but people can hear me, so I have to be a little bit more quieter. I normally do. So this is probably like ASMR version of Requiro. And also in this week's video there are a couple of documents. I'm just going to say they came out on the day, but not going to cover like I normally do, just because they are 60 plus pages long and I don't want these videos to go on forever, and I'll just make it its own dedicated video. Some of them are just transcripts from Luigi Mangione's court hearings, and then the other ones are just really big documents like motions, etc. and stuff like that. So I'll make those their own dedicated video after I do all the updates and all that in Luigi Mangione's case, and then probably for like a month it'll just be audio versions of those documents. But I think it's necessary to do that just to have all the accurate information all in one place for people to see and watch, etc., even if this channel is not as big as it used to be. So I do want to add this here before we get into the main part of the video, but some really important things have been going on in Luigi Mangione's case that have been really big. So like we already know, Luigi Mangione's trial dates have been set by Judge Carro and also Judge Garnett, and basically a couple of weeks ago Karen Ocafillo submitted a order or letter, I don't remember at the moment, apologize, but basically asking Judge Garnett, hey, can we please reschedule the court date that was scheduled by Judge Carro to January 2027, basically next year, just because literally Luigi Mangione can't be in two places at once, neither can Luigi Mangione's legal team, because literally the date Judge Carro set is put right in the middle of basically the court date that was set by literally a couple of days ago. There was a response to Karen Ocafillo's order/letter basically asking if they can push back that court date Judge Carro set. Basically the response was saying, no, we are not going to reschedule that court date that Judge Carro set, but we are going to basically change the jury selection date, and it's absolute bullshit for them to do that, because literally it's double jeopardy, it's blunt and clear, everyone can see it, and then for them to do that is absolutely infuriating. And as me recording this video, a document did come out by Karen Ocafillo. Technically for me it is March 24th 2026, but in the rest of the world it is March 23rd 2026. But basically today it came out, they are scheduling another court date for Luigi Mangione to appear in court date and organize and figure out how to fix this scheduling problem with literally having the two trials happen at once, and that is going to be happening on April 1st 2026. And I'm honestly surprised, like that literally came out today as me recording this video, like I saw it when I woke up this morning, and I'm honestly surprised how fast this is actually happening, because I thought this would normally take a little bit more longer, because, you know, sometimes they like to drag their feet, but I'm surprised how fast this is actually going forward. But I think it would be very good for them to do this, because this is them just arguing, hey, Luigi can't be there in two places at the same time. We need to solve this. So basically that's what's gonna happen. Just thought I should put that here. There are some really big things happening because, you know, scheduling for Luigi Mangione's trial is a really big thing, and Double Jeopardy is 100% happening, and all the information and all the sources for this week's video will be up on this week's episode on the website, so if you want to go check it out, it's all there. And if there's anything I got wrong or any mistakes or anything like that, please let me know in the comments down below, and I'll sure to pin it or bring it up in my next video. I am one person working on all these videos. Now, let's get into the video. November 25th, 2025. Now, please do take this document with a little bit of skepticism. I did get this from Instagram, and this document is from Thomas Dickey, and I do want to say this here. I'm not sure if I read this document already, and I just forgot about it. I go through so many documents when I make these videos. I don't remember them all. So I'm not sure if I actually read this document anyway, or it's recently been available to the public, and the little stamp that's actually on the document says November 5th, 2025. That was when it was originally filed and done and all that. So I'm just putting this here anyway. If I missed it, it's here. If I did do it, I do apologize. Let me know if I already covered this document or not. I don't remember. But basically this document is just Thomas Dickey saying, hey, Luigi Mangione can't be there in person in Pennsylvania because, you know, he's busy in New York. We've seen many of those documents in the past, but again, it's more like a scheduling thing, keeping all the information all in one place, you know, for people to get access to if they want to see it in the future. Anyway, so I'll pop the document up on screen for you guys.
In the Court of Common Pleas of Blair County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania vs. Luigi Nicholas Mangione, Defendant, CP 07CR0002724-2024 Notice of Defendants, Unavailability for Personal Appearance in the Blair County Court of Common Pleas and Praecipe for Consent to Remote Appearance, filed on behalf of Commonwealth of Pennsylvania Peter J. Weeks, Esquire District Attorney PA, ID 201,051 Nicole M. Smith, Esquire First Assistant District Attorney PA, ID 200,855 Office of the District Attorney Blair County Courthouse 423 Allegheny Street, Suite 421 Hollidaysburg, Pennsylvania 16648, 814-693-3010 Counsel of Record, Thomas M. Dickey, ESQ. On or about December 19, 2024, Defendant Mangione elected to waive his preliminary hearing with a preservation of habeas and then waived extradition to the state of New York, where he faces homicide, and related waivers would cause him to be removed from the jurisdiction of Blair County in order to first prosecute him on his homicide case. The undersigned served detainer by email and hand service to secure Defendant Mangione's appearance after his homicide prosecution. Notably, the logistics and costs for the transportation and housing of Defendant Mangione were significantly greater than a typical inmate due to the media and public attention generated by the New York allegations. Further, there were significant security concerns regarding the custody and transportation of Defendant Mangione due to the public attention the case has received and the threats received by the criminal justice system regarding Defendant Mangione's prosecution. Subsequent to Defendant Mangione's custody being transferred from the Blair County Sheriff to the New York City Police Department, he was taken into custody by the United States government on a federal indictment for homicide and related charges. Consequently, Defendant Mangione was detained in a federal prison where he remains. The undersigned has been in communication with Assistant United States Attorney Frank Balsamillo and the other United States attorneys prosecuting Defendant Mangione for the purposes of providing discovery to the United States government and to ascertain whether Defendant Mangione would be physically available for court appearances in Blair County during the pendency of his federal prosecution. On or about February 12, 2025, the undersigned received a letter from the United States Attorney's Southern District of New York, which indicated that Defendant Mangione would not be made physically available to Blair County until the disposition of his federal charges, including any sentencing proceedings. The letter also indicates that Defendant Mangione will be made available via video conference should he elect to proceed in any or all stages of his Blair County prosecution remotely. The Commonwealth received Defendant Mangone's Praecipe to schedule hearing and demand for personal appearance on or about June 20, 2025 and immediately reached out to the Federal Prosecutor's Office in New York. On or about June 20, 2025, the undersigned received a letter from the United States Attorney's Southern District of New York, which indicated that Defendant Mangione would not be made physically available to Blair County until the disposition of his federal charges, including any sentencing proceedings. The letter also indicates that Defendant Mangione will be made available via video conference should he elect to proceed in any or all stages of his Blair County prosecution remotely. Subsequent to this correspondence and at the demand of Defendant Mangone's attorney, who repeatedly has declined to allow Defendant Mangione to participate remotely, the Commonwealth filed a petition for writ of habeas corpus ad prosequendum with the court. The writ was eventually signed by the court and forwarded to the United States Attorney's Office, who ultimately denied the writ. 10. The court has ordered the Commonwealth to provide continuous additional updates on the availability of Defendant Mangione, and the same is addressed by this notice. The position of the United States Attorney's Office regarding the physical unavailability of Defendant Mangione has made Defendant Mangione unavailable pursuant to PAR, Crim P 600. The Commonwealth's detainer and previously filed writ of habeas corpus ad prosequendum reflects its intent to secure Defendant Mangione once he is physically available for prosecution in Blair County 11. Notably, the Commonwealth is aware of a pending pre-trial motion in Manhattan, New York, where the involved Blair County law enforcement officials will be presenting testimony. The hearing for this motion is scheduled for early December 2025, and it is anticipated that the defendant will be present for that hearing. The Commonwealth asserts that the instant motion may be decided by the court after submission of the transcripts from the New York hearing, thereby eliminating the need for a hearing or the personal appearance of Defendant Mangione. Wherefore, the Commonwealth of Pennsylvania respectfully requests this honorable court to enter an order acknowledging receipt of the attached correspondence and Defendant Mangone's unavailability, pursuant to PAR, Crim P 600 unless Defendant Mangione elects to appear via video conferencing. Respectfully submitted, 220 Peter J. Weeks, Blair County District Attorney, Blair County District Attorney's Office, 423 Allegheny Street, St. 421 Hollidaysburg, Pennsylvania 16648, 814-693-3010. Respectfully submitted, Nicole M. Smith, First Assistant District Attorney, Blair County District Attorney's Office. In the Court of Common Pleas of Blair County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania vs. Luigi Nicholas Mangione, Defendant, CP 07CR000274-2024 Certificate of Compliance. I certify that this filing complies with the provisions of the Public Access Policy of the Unified Judicial System of Pennsylvania. Case recorders of the appellate and trial courts that require filing confidential information and documents differently than non-confidential information and documents, respectfully submitted, file Peter J. Weeks, District Attorney. In the Court of Common Pleas of Blair County, Pennsylvania Criminal Division, Commonwealth of Pennsylvania vs. Luigi Nicholas Mangione, Defendant, CP 07CR000274-2024, Certificate of Service. I, Peter J. Weeks, District Attorney, do hereby certify that I have served on this day a true and correct copy of the foregoing motion via email to Thomas M. Dickey, Esquire, ESQ 308 Orchard Avenue, Altoona, Pennsylvania 16602. Date, November 25, 2025.
So basically the whole breakdown of this document, I'm going to step that like I normally do with every other document just because I don't remember if I talked about this or not already, but basically it's just Thomas Dickey saying the prosecution in Pennsylvania, they don't want to send him to Pennsylvania from New York because they thought it's going to be way too expensive to send Luigi to Pennsylvania from New York and then also hold him there and keep him contained in Pennsylvania, and prosecution said they did, and then they said they won't because it's too expensive, yada yada yada. They said, can we do it through Zoom? And Luigi Mangione says no, it's his right to do that in person, and basically it's just like back and forth for last couple of months for them saying that. Basically, that's what this document is, and basically explaining they tried to waive the extradition for Luigi Mangione to be sent to New York, but like we already know, it happened already. Anyway, I'm not going to go in depth of the breakdown of this document, because again, I don't remember if I talked about this or not already. I feel like I did, but I don't know. I'm just putting it here anyway. Anyway, next document. But if you guys don't remember, Luigi Mangione's case in Pennsylvania has been put on pause until everything in New York has been done and sorted. We covered that in one of my videos. I don't remember which one, but it was announced in one of those videos. Luigi Mangione's case in Pennsylvania is being put on pause until everything in New York has done and dusted for Luigi Mangione to be sent to Pennsylvania. 6th of December 2025. I actually brought this up in my videos going over the December suppression hearings. In those videos, I also brought it up there. Evidence was released to the public that was allegedly found in Luigi Mangione's backpack, and this was not meant to be released to the public whatsoever, and I'm not going to be showing you guys any of the alleged evidence found in Luigi Mangione's backpack for two reasons. So basically, the first reason is it has been deleted off the internet. It was like around for like probably 24 hours online, and then it got deleted from Reddit, Twitter, etc. But like we already know, people have probably taken a gazillion screenshots of all that kind of stuff. Second thing is, I am also doing this out of respect for Luigi Mangione's legal team, because they never wanted any of the alleged evidence to be released to the public. I know, as a person who is covering Luigi Mangione's case, and my goal is to keep all the current and factual information all in one place, it would be helpful to keep all the evidence here for everyone to see. But I'm doing it out of respect because I have shit called morals. It's never meant to be spread around everywhere on the internet like it's already done, and me doing that here is not helping. And if you guys want to see the alleged evidence and all that, you'll probably definitely find it on someone else's channel that's way bigger than mine, and they've definitely talked about it. It's been spread around all around everywhere. Alleged evidence or anything like that in Luigi Mangione's backpack, but other channels and all that will 100% do it, because like we already know, once you say Luigi Mangione, a big channel, it goes viral, everyone sees it, everyone watches it. Unless you're my little channel, you just get taken down. Anyway, I'm so annoyed about that, by the way, YouTube. 7th of December 2025, more evidence was released on this day to the public, again when it wasn't meant to be released whatsoever. Brought that up in my videos going over the December suppression hearing in Luigi Mangione's case. So I do want to put this here as well. So I did bring this up in my December suppression hearing videos. I don't remember which one, it was one of them, but it did come out when I was making those videos. And I do want to say this here. One, it could be absolute bullshit, but two, the amount of stuff that came out from it is literally from a bunch of different people. It very much sounds like it was very much a real thing. Now, a person that is a Luigi Mangione supporter, I'm not going to say her name because one, I don't remember it. I don't remember any of the drama people names in this, and I also don't get involved, and I don't care enough to get involved. But basically, a Luigi Mangione supporter, they're quite big in the Luigi Mangione supporter community, and it basically came out from screenshots from Discord and other social media platforms. Basically, this person managed to became friends with someone in the courthouse and managed to get access to CCTV camera footage in this case, and also some body cam footage and also some photos, and release that to the public. And I think it's a very gross and scummy thing for someone to be a Luigi Mangione supporter and claiming and posting this kind of stuff to the actual public, and sneaking their way in to actually do that. I think it's very gross. I feel like it's a crime or something, I don't know, but I feel like it is. But I feel like it's a very gross and scummy thing for them to do that, to like literally say they are supporting him, but then release that kind of stuff to the public when it wasn't meant to be released whatsoever. But the damage has already been done. It's already been released. They've already done it. Now, I did bring that up. It is reposted on my Instagram if you guys want to go read all the screenshots and stuff like that. I will talk about this in the video, in the part where it's like things aren't really relating to his case, but things that are relating to his case. That little section in the video. You guys know me, don't get involved with the drama and all that surrounding the Luigi Mangione supporters. There's a lot out there. I don't get involved. I look at documents and I leave, and it's sad to see it. But I will go over that in a lot more detail later on in the video, and I just want to put that here. That also happened as well. The 8th of December 2025. Basically, this is a letter addressed to Judge Garnett for them requesting can they have more time, and surprisingly this document isn't from Carro or Mark. We will see a document from Mark later on in the video, but this is actually from Avraham Moskowitz on the behalf of Carro and also Mark because they're busy in the December suppression hearing that's going on in Luigi Mangione's case in this moment in time. So I'll pop the document up on screen for you guys.
By ECF Hon, Margaret M. Garnett, U.S. District Judge, U.S. Courthouse, 40 Foley Square, New York, NY 10007. Dear Judge Garnett, December 8, 2025. Re. U.S. vs. Luigi Mangione 25 CR 176, MMG. This letter is respectfully submitted on behalf of the defendant Luigi Mangione to request a 1-week extension of time to file an omnibus reply brief related to the defense motions currently pending before the court in this case. The reply brief is currently due on December 12, and if the court grants the extension, it will be filed on or before December 19, 2025. The extension is necessary to allow sufficient time for Mr. Mangione's lead trial counsel, Karen Friedman Anafilo and Mark Anafolo, who are currently participating in a lengthy suppression hearing before Justice Carro in Supreme Court, New York County, on Mr. Mangione's state case, to participate in the drafting of the reply brief. We have discussed this matter with counsel for the government, and they have advised that they have no objection to the requested extension. The parties agree that if the court grants the extension, the pre-trial conference on January 9, 2026, should proceed as scheduled. Thank you in advance for your consideration of this request. CC, all counsel of record, by ECF, respectfully submitted, Avraham C. Moskowitz.
So basically in this document it was just them asking, hey, can we have 1 more week so we can have more time to prepare and all that, because they're Karen and Mark are busy in Luigi Mangione December suppression hearing, and they said if this is granted, they'll have the documents submitted before December 9th, 2025, and the scheduled, and basically the January 9th, 2026 pre-trial conference will stay as scheduled as normal. December 9th, 2025, this is a document from Karen I'll pop it up on screen for you guys.
The Honorable Gregory Carro Anafilo Intrata Supreme Court of the State of New York, 100 Center Street, Part 32, New York, New York 10013. Re. People v. Luigi Mangione, IND, number 75657/2024. Dear Judge Carro, December 9, 2025. On Tuesday, December 2, 2025, counsel made an oral application in court to seal body-worn camera footage that was admitted as exhibits at the hearing and displayed in DPEN court. Counsel argued that providing this footage to the media, which contains evidence and statements that are subject to suppression, creates a substantial probability that Mr. Mangione's right to a fair trial will be prejudiced if potential jurors see this footage in the media. Counsel further noted that this serious prejudice would apply not only to the alleged murder charges pending before this court, but also to the concurrent federal case where the government is seeking the death penalty. After hearing counsel's application, this court ruled that the body-worn camera footage exhibits that were played in court would be sealed and not provided to the media. In making the sealing request, counsel relied on Daily News, LP v. Wiley, 126 AD, 3D 511, First Step 2015, where the media requested the defendant's videotaped confession in the Eaton Pats case that was subject to a suppression hearing. In denying the media's request, Judge Wiley found that the proper balance between a defendant's right to a fair trial and the media's First Amendment rights was to allow the confession to be played in a public courtroom in front of the media, but to not provide a copy of the videoed confession to the media. In reviewing Judge Wiley's ruling, the First Department noted that decisions to seal or disclose records fall within the inherent power of the court to control the records of its own proceeding. ID, at 512. The First Department further noted that While a court must guarantee that the defendant receives a fair trial, it must do so in a manner that balances the interests of the defendant, jurors, witnesses, attorneys and the public at large. ID. Relying on precedent from the NY Court of Appeals, the First Department noted that the defendant must demonstrate a strong likelihood that particular evidence would prejudice the defendant's trial if disclosed to potential jurors. ID. Citing matter of Westchester Rockland Newspapers v. Leggett, 48 NY, 2D 430, 438, 1979. In addition, the First Department noted that the defendant bears the burden of showing that his or her right to a fair trial may be compromised by an open proceeding, and that the trial court must make specific findings that closure would prevent a substantial probability that the defendant's right to a fair trial would be prejudiced by publicity, and that there are no reasonable alternatives to closure to protect the defendant's fair trial rights. Wiley, 126 AD, 3D at 513. After balancing the media's First Amendment rights and a defendant's right to a fair trial, the First Department upheld Judge Wiley's ruling that the media has not established a clear right to the relief they seek. ID. In doing so, the court noted that the suppression hearing was held in open court, with the press in attendance. ID. Furthermore, the First Department noted that Judge Wiley had not yet ruled on the admissibility of the videotaped confession, that the redacted version of the confession was played at trial, and that the redacted version was released to the media after trial. Under those circumstances, the First Department found no clear error in Judge Wiley's ruling. The Wiley analysis applies here as well. The body-worn camera footage at issue was admitted at trial and played in open court in front of the media. Just as in Wiley, allowing the media access to the body-worn camera footage would create a substantial probability that Mr. Mangone's fair trial rights would be prejudiced by the publicity. After all, the prosecution is seeking to admit Mr. Mangone's statements in the body camera footage at trial because the DA's office believes these statements can be used to establish Mr. Mangone's guilt. Similarly, the body-worn camera footage depicts the search of Mr. Mangone's backpack, which is the subject of the hearing. The prosecution is seeking to use the evidence recovered from the backpack, including a gun, a silencer and Mr. Mangone's writings, to prove Mr. Mangone's guilt. As such, providing the body-worn camera footage to the media to be repeatedly played before Mr. Mangone's state and federal trials creates a substantial probability that Mr. Mangone's right to a fair trial will be prejudiced by potential jurors seeing this footage in the media. In response to Mr. Mangone's application, an attorney representing several media outlets filed a letter with this court seeking 1. A meaningful opportunity to be heard before any sealing or closure decision, and 2. That the court should reconsider its decision to seal the body-worn camera footage. Counsel agrees with the media first request, but continues to object to the release of the body-worn camera footage. The media's request cites the Second Circuit's decision in application of Nati Broad Company, Incorporated, 635 F, 2D 945, 2D C 1980, NBC case, to support its claim that the body-worn camera footage should be unsealed since they were disclosed to the public and press in open court. Ballin, 12 May 2025, letter at 5. That case, however, is readily distinguishable. There, the media sought to copy and televise all videotapes admitted into evidence at one of the first abscam cases pending in the Eastern District of New York. In finding that the trial court properly sided with the media in releasing the videotapes, the Second Circuit relied on the fact that the videotape evidence showed the actions of public officials, both the defendants and law enforcement personnel, and that, though the videotape transcripts had been provided to the public, there remains a legitimate and important interest in affording members of the public their own opportunity to see and hear evidence that records the activities of a member of Congress and local elected officials, as well as agents of the Federal Bureau of Investigation, 635 F, 2D at 952. Here, in contrast, Mr. Mangone's alleged conduct does not implicate politicians or the FBI. Moreover, as the media in the NBC case was seeking evidence that had been admitted at trial after the jury had been selected, there was no concern that releasing the evidence would prejudice the trial defendant's right to a fair trial. Here, on the other hand, the media is requesting evidence from a suppression hearing before a jury has been selected. In this scenario, releasing this evidence to the media would create a substantial probability that Mr. Mangone's right to a fair trial would be prejudiced by publicity. Notably, the Second Circuit addressed the potential prejudice that releasing the videotapes to the media would have on the other abscam defendants who were still awaiting trial. While acknowledging the potential for prejudice to these defendants, the Second Circuit nevertheless noted that the defendants and the media frequently overestimate the extent of the public's awareness of the news. ID, at 953. Specifically, the Second Circuit noted that despite the extensive publicity about abscam that unfortunately accompanied the initial revelations and that was legitimately renewed when the indictments were returned, about half of those summoned for jury selection had no knowledge of abscam, and only a handful had more than cursory knowledge. ID. Needless to say, the same is not true here, as the public attention to this case is unprecedented. See, for example, Ballin the 12th of May 2025 letter at 1N1, citing 5 news articles including articles in CNN, BBC, ABC News, the NY Times and Bloomberg describing the second day of the suppression hearings in this case. Given the extreme media coverage of this case, releasing the body-worn camera footage in this case would create a substantial probability that Mr. Mangone's right to a fair trial would be prejudiced. Lastly, the media claims that there are less restrictive alternatives to sealing the exhibits, including the implementation of a careful voir dire process at the time of trial and the use of clear jury instructions. ID, at 5. As Judge Jack Weinstein noted in NBC Universal, Incorporated, such measures are inadequate to prevent prejudice. Voir dire would be an insufficient cure if a large segment of the citizens in this district are exposed to the prejudicial information. Exclusion of a considerable portion of the population would skew the panel, making it more difficult to find a cross-section of the community. Jurors' assurances that they have not been influenced by media reports are not necessarily dispositive. 426 F sub 2 D49, 58, EDNY 2006. This court should find the same. Accordingly, this court should not reconsider its ruling sealing the body-worn camera footage. Respectfully submitted, Karen Friedman, Anafilo Mark Anafilo Jacob Kaplan, counsel for Luigi Mangione.
So that was the end of that little document from Karen Anafilo. Basically, the document says on December 2nd, 2025, it was announced saying they will not release any of the evidence to the public whatsoever, just because the jury will be influenced and also the public will be influenced of basically what they see on social media, from the news, the media, etc. if this alleged evidence was released to the public. And like we already know, this has already been released to the public. It's infuriating, but this is basically them requesting, hey, we don't want this to be released whatsoever, but because it'll give Luigi Mangione a unfair trial. Like we already know, they've been doing that since the beginning, and it will make a unfair case for Luigi Mangione's federal case and also state case. And basically it's also brought up in literally him dealing with the death penalty. I do want to add here, the death penalty has been officially taken off the table. That was announced in January. Just want to add that here, but this is before this was officially announced. But again, Luigi Mangione doesn't have to deal with the death penalty hovering over his head anymore. But basically, it can give Luigi Mangione a unfair trial just because of what people see and what the media tells them, and it will give basically Luigi a unfair trial. They see that evidence that was allegedly in Luigi Mangione's backpack and them thinking that it's like, oh yeah, he did this, allegedly, instead of, actually looking at the document and seeing what's actually going on, because sadly these days people don't have visual thinking skills. Just in general, it's alarming, honestly. Don't believe everything the media tells you guys, just think about things a little bit harder and look into things more. I do it, but sometimes I don't, sometimes I forget. People need to hold me accountable when I do that, please. Also bring up, in the December suppression hearing, the media was there. They could see the CCTV camera footage and also body cam footage from the officers in Altoona. They are able to go out and report it and spread misinformation or even make shit up about it and release it to the public, and people will eat that shit up, because literally there was like no cameras, no video cameras or anything like that in the courtroom, and people would take anything they hear about Luigi Mangione as fact instead of looking into things more. And the prosecution, they want to use the body cam footage in their case and use it against for Luigi Mangione. And if the body cam footage is suppressed and the public already seen it, and the public have already seen it and it's been suppressed already because it was released before it was suppressed, it gives a unfair advantage to the prosecution and the jury selection, because, you know, people have already seen it. Like we know, some of it was actually released to the public, like when Luigi Mangione was at the McDonald's, and same thing with the body cam in the actual police car. Again, I'm not going to be showing you guys any of that body cam footage whatsoever. It was not meant to be released whatsoever. Again, respect thing, I'm not going to be showing you guys that whatsoever. If you want to see it, it's everywhere, okay? It's there. It's, again, bigger, popular YouTube channels, they've already talked about it, they've already played the full video, etc. They've probably made commentary channel things about it already. If you want to go find it, it's really easy to find if you want to, but it was not meant to be released whatsoever. Again, it's not really helping Luigi Mangione if it was released to the public, like we already know it was, compared to it being suppressed, and then it's already been released. It's kind of a little bit pointless at that point. When it comes out, basically a person of the media requested, hey, can they have access to the body cam footage and talk about it, and basically, and then the second thing that was requested and asked, can they release the body cam footage to the public, and in the document it comes out they can't do the first option, but they agreed to the second option. And again, it's very annoying and very infuriating for that to happen. They said, no, you can have a media, but like, we'll release it to the public anyway, because again, it gives a unfair bias towards Luigi Mangione. Like we already know, this entire trial has been unfair towards Luigi whatsoever, ever since the beginning. They also bring up in the document, it kind of makes Luigi Mangione have an unfair jury selection, because say they would see the alleged evidence on like Twitter, TikTok, wherever, Reddit, yada yada yada, every other social media platform in the world, etc. If they've seen that on there instead of actually seeing it on the actual official day, Luigi Mangione's actual trial, and making up their own decision on the actual day instead of like beforehand, when that's not meant to happen whatsoever. And again, unfair for Luigi Mangione and also his jury selection because of them doing that. And like we already know, there's already been so many big people in power that have been making these additional comments towards Luigi Mangione. It's really weird how much they love getting involved, those guys, like the old mayor of New York, Donald Trump, the president of the United States, Pat Bondi, the district attorney, placing the death penalty on Luigi Mangione because she wants to, because she gets money from the United Healthcare. We go in more detail about that later on in this video. It's a big fucking thing, and like we already know, some people really like those people, and when those people say something and people look at the media and take their words as fact because, you know, they like them, instead of actually thinking literally, it isn't fair on Luigi Mangione or his case because of that reason. And then also on top of that, with them releasing the body cam footage, alleged evidence to the public, etc., isn't helping him whatsoever. Again, they're just putting more and more things against Luigi Mangione. Honestly, I feel like they're all doing this because they don't really, I feel like they're doing this because literally, I don't think the prosecutions have really a leg to stand on, allegedly. They also bring up another example of jury selection where some people kind of knew what was going on in the case, and the other part of the jury selection in that case, basically it was okay because they didn't know everything and all the nitty-gritty details what was going on in that case, so it was okay. But compared to this case, just because of the amount of media attention and everything surrounding Luigi Mangione's case, this is very, very different compared to other cases that happened in the past. just because of how viral this entire case is and the media attention, the frickin' politics are getting involved, everyone online is making posts about this case. Just because of how viral this entire case is, it's a very different situation compared to every other case in the past for Luigi Mangione to have that as an option of some people kind of know what's going on, and some people don't. It's very much, a lot of people know what's going on, and they have very heavy opinions about it in this case. So it is a very different situation here compared to every other case that has happened in the past, they say in this document. And it's very true. The 10th of December 2025, a couple of documents did come out on this day. This is basically a document requesting, can we have an extension for the 70-page motion for Luigi Mangione's case, and it was also accepted and granted on this day as well. So I'll put the document up on screen for you guys.
The Honorable Gregory Carro Anafilo Intrata Supreme Court of the State of New York 100 Center Street, Part 32 New York 10013 Re. People v. Luigi Mangione, IND, number 75657/2024. Dear Judge Carro, December 9, 2025. On Tuesday, December 2, 2025, Counsel made an oral application in court to seal body-worn camera footage that was admitted as exhibits at the hearing and displayed in DPEN court. Counsel argued that providing this footage to the media, which contains evidence and statements that are subject to suppression, creates a substantial probability that Mr. Mangione's right to a fair trial will be prejudiced if potential jurors see this footage in the media. Counsel further noted that this serious prejudice would apply not only to the alleged murder charges pending before this court, but also to the concurrent federal case where the government is seeking the death penalty. After hearing counsel's application, this court ruled that the body-worn camera footage exhibits that were played in court would be sealed and not provided to the media. In making the sealing request, counsel relied on Daily News, LP v. Wiley, 126 AD, 3D 511, First Step 2015, where the media requested the defendant's videotaped confession in the Eaton Pats case that was subject to a suppression hearing. In denying the media's request, Judge Wiley found that the proper balance between a defendant's right to a fair trial and the media's First Amendment rights was to allow the confession to be played in a public courtroom in front of the media, but to not provide a copy of the videoed confession to the media. In reviewing Judge Wiley's ruling, the First Department noted that decisions to seal or disclose records fall within the inherent power of the court to control the records of its own proceeding. ID, at 512. The First Department further noted that higher court must guarantee that the defendant receives a fair trial. It must do so in a manner that balances the interests of the defendant, jurors, witnesses, attorneys and the public at large. ID, relying on precedent from the NY Court of Appeals, the First Department noted that the defendant must demonstrate a strong likelihood that particular evidence would prejudice the defendant's trial if disclosed to potential jurors. ID, citing matter of Westchester Rockland Newspapers v. Leggett, 48 NY, 2D 430, 438, 1979. In addition, the First Department noted that the defendant bears the burden of showing that his or her right to a fair trial may be compromised by an open proceeding, and that the trial court must make specific findings that closure would prevent a substantial probability that the defendant's right to a fair trial would be prejudiced by publicity, and that there are no reasonable alternatives to closure to protect the defendant's fair trial rights. Wiley, 126 AD, 3D at 513. After balancing the media's First Amendment rights and a defendant's right to a fair trial, the First Department upheld Judge Wiley's ruling that the media has not established a clear right.
Now this next document I'm going to show you guys is the document from the prosecutors, and basically this document is just saying, hey, if you are going to release little snippets of body cam footage of the police officers' uncertainty and asking, do we need a search warrant, and releasing that little clip to the public instead of the full body cam footage to the public to Luigi Mangione legal team. And I do want to say this here, please take this document with a little bit of skepticism. I did get this document from Instagram. I'll pop it up on screen for you guys.
District Attorney County of New York 1 Hogan Place, New York, NY10013-212-335-9000 Alvin L. Bragg Jr., District Attorney December 10, 2025 by hand delivery and email. The Honorable Gregory Carro, Justice of the Supreme Court of the State of New York, 100 Center Street, Part 32, Room 1300, New York, New York, 10013 Re. People v. Luigi Mangione. Indictment No. IND 75657-24. Dear Judge Carro, we are writing to clarify the court's ruling yesterday permitting, upon the defense's request, public release of a small portion of the body-worn camera footage. After the court's ruling, the defense filed a letter reiterating their blanket sealing request for body-worn camera footage admitted into evidence at the hearing. To the extent the letter constitutes a withdrawal of their earlier application for limited release, we join in that application. However, to the extent the defense continues to seek release of the small portion they sought yesterday, but the sealing of all other footage, we ask the court to expand that ruling to permit release of several minutes of Carlo footage from the same exhibit that provides appropriate context. Left undisturbed, the defense would be free to release the limited footage consistent with their theory at these hearings in the name of the public's right to know, while simultaneously withholding from the public footage that contradicts that theory, and that places that same footage in appropriate context. This is unfairly prejudicial to the people and misleading to the public. As a preliminary matter, on December 2, 2025, the defense made an oral application to the court to seal all body-worn camera footage. The people have left the release of hearing evidence to the sound discretion of the court. On December 9, 2025, the court ordered that a 2-minute clip of the body-worn camera of Patrolman Fry be released to the press. At the request of the court, as with all other exhibits released, the people facilitated the release of said body-worn camera. Then, yesterday afternoon, the defense made an application to release additional body-worn camera footage. Specifically, the defense sought release of footage in which Corporal Trent and Corporal Miller opined that it would be prudent to get a search warrant. Corporal Trent's supervisor, Sergeant Burns, rejected that suggestion, noting that Altoona PD was arresting the defendant on local charges and had the right to search incident to arrest. U.A.S. 595-597, 600, Fox, 816, 823-824, 826-827. The approximately 5 minutes of footage that preceded the discussion of the search warrant should also be released to give fair context to the search warrant discussion. In the earlier footage, the same Corporal Trent advises P.O. to take the bag back to the station, but asks if there is a bomb. P.O. replies that is exactly what she is trying to ascertain. U.A.S. 587-88, 597, Fox transcript at 818-820-828. Furthermore, in that earlier footage, during the actual search of the bag, both Corporals Trent and Miller watched and neither suggested to either P.O. or Fox at the time of the search to obtain a search warrant. To the extent that counsel seeks release of a portion of body-worn camera footage in the name of the public's right to know, the release must include proper context and should not be edited to exclude footage that contradicts counsel's legal theory. In addition, we request release of the corresponding transcripts of the conversations during the released footage. Sincerely, Joel J. Seidman, Joel J. Seidman, Assistant District Attorney, Senior Trial Counsel.
So that was the document from the prosecutors. Basically, I found this kind of funny. In the document, the prosecution say this is prejudicial because basically Luigi Mangione's legal team, once they saw that body cam footage of one of the officers asking and being unsure, asking, do we need a search warrant, when they were searching for Luigi Mangione's backpack, and Luigi Mangione's legal team want that little clip and ask can they release that to the public, and the prosecution argues saying, hey, you're the ones who said you don't want any of the body cam footage or even CCTV camera footage or even evidence released to the public. Why are you guys wanting this little snippet to be released to the public? And they say this is prejudicial. Find that kind of hilarious. They're the ones saying that when they've been doing it the entire fucking time. And basically they argue if you want that little snippet of that clip of the Altoona police officer being unsure and asking do they need a search warrant to search Luigi Mangione's backpack at that McDonald's, or they should release the full unedited version of the body cam footage. That's what the prosecution are arguing, and that little snippet was granted to Luigi Mangione's legal team for them to release that to the public, not the full body cam footage, only that small little snippet that was released to the public. So I find this kind of funny. Basically, the prosecution are saying, hey, why aren't you guys playing by the rules? Why aren't you doing things by the book? And I find that kind of hilarious. Like, they've not been doing that the entire time. I can give you guys a couple of examples to refresh your memory of what the prosecution did. They listened to Luigi Mangione's phone call that was to one of his legal team. They lied to Luigi Mangione's medical insurance people so they can get all of their documents from them, and lying about a court date. Another thing they did was releasing evidence to the public and also body cam footage as well, when they weren't meant to do that whatsoever, and countless of other things they have done in Luigi Mangione's case. But then they're just going, why aren't they playing by the rules? This isn't fair. We need fairness. They're the ones to talk. So this is a screenshot from courtlistener.com. Basically, this is where the prosecution released their documents compared to Luigi Mangione's website. That's where a lot of Luigi Mangione's legal team released their documents compared to the prosecution. And I know I don't really do this because I don't think it's really relevant compared to the really big documents, but sometimes I have like little blurbs or sentences that are really important in Luigi Mangione's case. There's surprisingly a lot in this video. I do apologize about that, but there's a lot of really important information in these little itty bitty sentences or even big chunks they write on this website of just little blurbs of things and stuff. Hope I'm explaining this well, but I'll pop this up on the screen for you guys.
December 10th, 2025. Set/reset deadlines hearings as to Luigi Nicholas Mangione. Defendant replies due by the 19th of December 2025. W. December 10th, 2025. Set/reset deadlines hearings as to Luigi Nicholas Mangione. Reply brief due by the 19th of December 2025.
The 19th of December 2025, a couple of documents came out on this day. Basically, this document is from Karen Arcafillo requesting, can we have more words for our memorandum of law for Luigi Mangione's case? Basically, them requesting, can they have more words in their document? So I'll put the document up on the screen for you guys.
December 19th, 2025 by ECF, the Honorable Margaret M. Garnett, U.S. District Judge, Southern District of New York, 40 Foley Square, New York. NY 10007 Re, United States v. Mangione, 25 CR 176, MMG. Dear Judge Garnett, later today, Counsel will be filing a reply memorandum of law in support of Mr. Mangione's motions challenging the constitutionality of the death penalty, moving to dismiss counts 3 and 4 and moving to suppress evidence and statements. Although this court's individual rules limit reply memoranda of law to 3,500 words, Counsel respectfully requests permission to file an oversized brief so that Counsel can adequately address these various issues in one reply. We have spoken with the government, and they have no objection to our request. Thank you for your consideration. Respectfully submitted, Karen Friedman Anafilo Mark Anafilo Jacob Kaplan CC, Gut Counsel, via ECF, Moskowitz Colson Ginsburg and Schulman, via ECF.
And on this day, a response from Karen Arcafillo came out on this exact same day as well, and I'll make it its own dedicated video just because it is about 51 pages long, so I'll make that its own dedicated video, but I just want to note it came out on this day as well. The 31st of December 2025, this is a document of a attorney notice for Luigi Mangione, Christopher Nosever. So I'll put this document up on screen for you guys.
United States District Court for the Southern District of New York, United States of America. Plaintiff v. Luigi Nicholas Mangione. Defendant case number 25 CR 176, MMG. Appearance of counsel 2. The clerk of court and all parties of record. I am admitted or otherwise authorized to practice in this court, and I appear in this case as counsel for Luigi Mangione. Date: the 31st of December 2025. Attorney's signature Ilan Schulman ES 9955. Printed name and bar number Moskowitz Colson Ginsburg and Schulman, 80 Broad Street, Suite 1900, New York. New York 10004.
This is another screenshot from courtlistener.com that came out on this day, so I'll pop it up on screen for you guys.
Order as to Luigi Nicholas Mangione, in advance of the conference scheduled for January 9, 2026, at 11 a.m. The court requests that both parties be prepared for oral argument and to answer the court's questions regarding the defendant's motion to dismiss counts 3 and 4. The court will allot 30 minutes each to the government and the defense for this argument. As of the date of this order, given the extensive and excellent briefing by both sides on the other pending motions and the issues presented by those motions, the court does not believe oral argument on the remaining motions is necessary or would be helpful to the court. Second, the court hereby orders the defendant to submit a letter by no later than Tuesday, January 6, 2026, indicating whether, in light of the government's representation that it is only seeking to admit the defendant's statement giving his name as Mark and Mark Rosario, he is still seeking to suppress those statements. Because the defendant did not address this issue in his reply brief, the court is unclear whether that suppression argument has been abandoned in light of the government's representation. Third, the court hereby orders both the government and the defendant to submit a letter by no later than Tuesday, January 6, 2026, indicating whether they believe an evidentiary hearing is necessary to resolve the government's inventory search or inevitable discovery arguments, or any other aspect of the defendant's suppression motion regarding searches of his backpack, and, if so, what specific facts are either disputed or unknown but necessary to resolving the question. If the parties are in agreement, a joint letter will suffice. Finally, the government may, if it wishes, submit us a reply of no more than 5 pages on the defendant's argument regarding Ms. Bondi's relationship to Ballard Partners, made for the first time in reply. Any such reply must be filed by no later than Wednesday, January 7, 2026. Signed by Judge Margaret M. Garnett on the 31st of December 2025, Garnet, Margaret, entered. The 31st of December 2025, main document.
Important information came out in these little chunks of information they gave us on courtlistener.com. I normally don't really do this because they don't do it that much, but they did that quite a bit surprisingly in December and also in January surprisingly. And they also post documents up on there that are free to read in Luigi Mangione's case, and sometimes they don't have documents to read on courtlistener.com, and I would pay for them and show you guys, but I need money to live and eat and stuff, so I'll just have to rely on Reddit for now. Maybe when I'm
We're rich and gorgeous.
Other things in the future, but for now I need to prioritize living. To the 6th of January 2026, I am gonna get some coffee. I'll be back in a minute. Okay, I'm back with coffee, so if my lipstick seems a lot lighter, it's just because it's on my coffee cup. So this is a joint letter between Luigi Mangione's legal team and also the United States government. I'll pop it up on screen for you guys.
January 6, 2026 via ECF and email, the Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York. New York 10007 Re. United States vs. Mangione, 25 CR 176, MMG. Dear Judge Garnett, we submit this joint letter with the government in response to this court's December 31, 2025, Order 1, directing defense counsel to inform the court whether Mr. Mangione continues to seek suppression of his statements to law enforcement on December 9, 2024, providing his name as Mark and Mark Rosario, and 2. Directing the parties to inform the court whether they believe an evidentiary hearing is necessary to resolve the government's inventory search or inevitable discovery arguments. I, Mr. Mangione's motion to suppress statements as to the court's first inquiry, given the government's representation that it is only seeking to admit Mr. Mangione's December 9, 2024, statements to law enforcement providing his name as Mark and Mark Rosario, DKT 71, gut response at 105, defense counsel hereby withdraws Mr. Mangione's motion to suppress his statements to Mr. Mangione's motion to suppress the contents of his backpack. A Mr. Mangione's position as to the court's second inquiry, defense counsel submits that, based on the current record, There are two reasons why this court cannot deny Mr. Mangone's suppression motion relating to his backpack without first conducting an evidentiary hearing. First, as part of its omnibus response, the government argued that, even if the Altoona Police Department's searches of Mr. Mangone's backpack were improper, the evidence recovered from these warrantless searches would nevertheless be admissible because this evidence would inevitably have been recovered during a subsequent inventory search. Gov. Response at 99-102, 1 in support of this claim, the one as noted in Mr. Mangone's omnibus motion, the government would need to establish the following three elements listed in United States v. Mendez, 315 F, 3D 132, 138, 2D C 2002, before it could rely on a mix of inevitable discovery through a valid inventory search to admit otherwise illegally obtained evidence. 1. That the government had legitimate custody of the property being searched so that an inventory search would have been justified. 2. That when the police in the government argues that it would meet the second Mendez factor because the Altoona Police Department had established procedures pursuant to which the property of arrestees is routinely searched and inventoried. Gov. Response at 100. One of the written procedures that the government relies on is Altoona Police Department General Order, the 1st of March 2010, which addresses the secure storage of detainee property, ID, at X6. This section, however, refers to a documented itemized inventory of all items taken from the detainee, that is, property taken off the detainee's person, as opposed to other property that law enforcement recovered at the time of the detainee's arrest that was not on the detainee's person. Notably, at Mr. Mangone's state suppression hearing, Sergeant John Burns of the Altoona Police Department testified that General Order 3 January 2010 pertained to inventorying property that was taken from the detainee's person and any property that he had with him at the time of being detained or arrested. HR 1107. Given this testimony, it is unclear whether this provision would pertain to Mr. Mangone's backpack, which was not in Mr. Mangone's control at the time he was detained or arrested. At a minimum, this ambiguity presents a factual dispute that cannot be resolved on the current record. Thus, without witness testimony regarding this provision, the government cannot establish that the Altoona Police Department had procedures in place regarding inventory searches of a defendant's backpack that was not in his control at the time of his arrest. Similarly, the government relies on an undated document from the Altoona Police Department Probationary Officer Training Task entitled Custodial Arrest Procedures, Summary, Misdemeanor, and Felony Offenses, ID, at X5. Notably, this document is for probationary officer training and is not part of the Altoona Police Department's general orders. Consequently, it is unclear what role, if any, this undated probationary training document has in establishing the Altoona Police Department's current procedures to, in contrast, General Order 3.1, which includes General Order 3 January 2010 discussed above, specifically states that the purpose of this general order is to provide personnel with guidelines on the operation of the Altoona Police Department's holding facility. This general order establishes procedures to ensure the facility is maintained in a secure and sanitary manner, with the safety of departmental personnel and detainees as a priority. ID, at X5 at page 2. Therefore, based on the current record and absent an evidentiary hearing, this court cannot rely on this undated probationary training document to determine that the government has established the second Mendez factor. Second, even assuming the government could establish that the Altoona Police Department had procedures in place regarding inventory searches of a defendant's backpack that was not in his control at the time of his arrest, an evidentiary hearing would still be required before the court could determine that the government has met the third Mendez factor, that is, that the inventory procedures would have inevitably led to discovery of the challenged evidence. Specifically, to the extent the Altoona Police Department's procedures set guidelines for inventory searches, these police agency in question conducted inventory searches, they did so pursuant to established or standardized procedures, and 3. That those inventory procedures would have inevitably led to the discovery of the challenged evidence. DKT 59-2, Omnibus Motion at 33, quoting Mendez, too tellingly. While the Altoona officers and the New York County District Attorney's Office attempted to use General Order 3 January 2010 at the state suppression hearing to establish a guideline for inventory searches, Neither law enforcement nor the state prosecutors even attempted to rely on this undated probationary officer training document. Guidelines would only allow law enforcement to inventory the fact that they recovered a journal. These procedures would not allow law enforcement to read the contents of the journal, absent a search warrant. Here, however, law enforcement officers read through the journal while conducting their warrantless searches. HR 1101-02. Sergeant John Burns testifying that he read through portions of the journal out of curiosity. HR 1234-35. Sergeant Eric Houston testifying that he read through the journal and photographed pages that appeared pertinent to the NYPD's investigation. HR 735. Patrolwoman Christy Wasser testifying that she flipped through a few pages of the journal. Because law enforcement's conduct in reading the journal exceeded its written inventory search procedures, the government cannot establish, based on the current record, that the inventory procedures would have inevitably led to discovery of the contents of Mr. Mangone's journal, as required by the third Mendez factor. Accordingly, while an evidentiary hearing is not required for this court to reject the government's inevitable discovery/inventory search arguments as to the contents of the journal on the current record, the court would require additional factual development through an evidentiary hearing before finding that the government has satisfied the third Mendez factor. 3. The government's position. The government disagrees with the defendant's characterization of the facts purportedly in dispute. The court can resolve each of the issues raised based on the record already before it, without any need for additional fact development or an evidentiary hearing. The majority of the defendant's complaints stem from his interpretation and application of United States v. Mendez, 315 F, 3D 132, 138, 2D C 2002, which presents a pure question of law appropriately decided by the court. The defendant has not identified any genuine material factual dispute that would preclude resolution on the existing record, which is more than sufficient for the court to decide the pending issues as a matter of law. Respectfully submitted, /S. Avraham C. Moskowitz, Elon Schulman, Christopher Neff, Moskowitz, Colson, Ginsburg, Ann Schulman, Karen Friedman, Anafilo, Mark Anafilo, Jacob Kaplan, Anafilo, Intrater LLPCC, Gut Counsel, by ECF. 3. In a footnote, the government argues, based on United States v. Whitehorn, 829 F, 2D 1225, 1230, 2D C 1987, that the contents of the backpack would also be admissible based on the inevitable discovery through subsequent search warrants by the government, the New York County District Attorney's Office and the District Attorney of Blair County. Gov. Response at 102 N. 32. However, these search warrants rely heavily on information illegally obtained through the unconstitutional search of Mr. Mangone's backpack and journal. Defense counsel submits that, once all the tainted information is removed from the warrants, the search warrant application lacked probable cause supporting the warrants.
So this is a joint letter from Luigi Mangione's legal team and also the United States government, and basically it's saying they want to suppress all of Luigi Mangione's statements he made to the Altoona police force before his Miranda rights were read to him, and including the fake ID Luigi Mangione handed over to the Altoona police. And then the second thing they said, they also want all the alleged evidence they found in Luigi Mangione's backpack to be suppressed as well, and then they want to organize a evidentiary hearing to organize that. And it also comes out as well, basically the reason why they want to organize a evidentiary hearing, I'm sorry I'm messing that up, but the reason why they want to organize that is because even the prosecution said once Luigi Mangione's backpack was even taken from the McDonald's all the way to the police station, the prosecution, we also heard the Altoona police officers say this as well, saying they would find all the stuff anyway in Luigi Mangione's backpack, even if they searched Luigi Mangione's backpack illegally at the McDonald's and multiple times at that police station, because, you know, they were gonna find the stuff anyway, and that's why they want the evidentiary hearing to happen as well. Rather have lipstick on one side of the cup that you can't see than like all over the cup like I normally would do. Someone's gonna take that out of context. and they were claiming they were doing a inventory search in Luigi Mangione's backpack, but in reality Luigi Mangione was not in control of his backpack whatsoever for them to actually do that. And even with the Altoona law, that's very outdated and doesn't really relate to this anymore. They are claiming to put this under that category of what they did was okay, quotation marks. I need to sometimes remember you guys aren't watching the screen. Basically they argue because literally they need a search warrant for this, and basically what they did was illegal and he was not in control of his backpack whatsoever. Like we already know, Luigi Mangione was 9 feet away from his backpack at the McDonald's and he was not in control from it whatsoever. And also on top of that, the amount of police officers that were also there as well. Again, Luigi Mangione was not in control of his backpack whatsoever. I went into that a lot more detail in my last couple of videos about the inventory search and someone needing to be in control or be there in their backpack for them to do that. Like, you know, if there's something sentimental there or something was stolen or like that, the person needs to be there instead of being away from his backpack. The Altoona police officers and also the prosecution are saying what they all did. We already know it's very much the fruit of the poisonous tree. We have not heard that saying since the beginning, but that's basically what it is. Because like if they were actually doing an inventory search of Luigi Mangione's backpack, what that they are claiming they were doing, it did not give them the right to actually go through and read the alleged notes they found in Luigi Mangione's backpack, and also the alleged writing from Luigi Mangione's journal they allegedly found in his backpack. And because like we already know, they were claiming they were doing an inventory search, and you're not meant to do that whatsoever, going through items or reading certain pages whatsoever. That's what they're not meant to do. They're only meant to write down saying, oh, this is a red notebook, and not go through the contents of that notebook whatsoever. But like we already know, it came out in the December suppression hearing. 2 officers came out and actually, you know, read the journal, and well, it also comes out a little bit later. Officer Waza also did read a couple of those pages of that notebook as well. Again, all of those officers who did that were doing the inventory search like they were claiming they were doing when they weren't. You know, you're not meant to do that whatsoever. And this is covered underneath Mendez factor, that is a law. So basically saying, yeah, they're not meant to go through evidence and read whatever is in the context of that evidence, like the alleged notebook they found on Luigi Mangione. And I'll put up on screen basically what third Mendez factor means up on the screen for you guys if you don't know what that means. So I'll put it up on the screen for you guys. Hi, it's voiceover me. So I actually looked around and tried find the actual like definition and of the third Mendez factor. They also bring up the second Mendez factor as well in this document as well, but I generally looked around and I could not find anything that actually explains what that actual law means. The only thing I could actually find was relating to the Mendez brothers, so I only know very little about that case, but it is relating to that case, I think, but I don't truly know whatsoever. But I just want to put that here. I did try to find this definition of what this law means, because you know I normally do that when they bring up a law quite a bit in these documents. But yeah, I do apologize about that. Maybe in the future if it's actually in like record books and stuff like that, and then I'll find it and bring it up in the future if this ever gets bring up again. But yeah, I do want to say sorry about that. I generally thought I could find something that rule means and stuff like that, but I actually could not. So maybe if I lived in the U.S. I could find it a lot easier compared to living in Australia, because I cannot find anything on my side of the world because of it. If you guys do come across it and know what the actual rule means or anything like that, please send it to me and I will bring it up in my next video or make a post about it, because again, this was brought up quite a bit in this document. Anyway, bye. This is a motion to omission. Basically, this is them hiring someone for Luigi Mangione for the 9th of January 2025 for Luigi Mangione when we see him next in court. So I'll pop the document up on screen for you guys.
United States District Court, Southern District of New York. Ex motion for admission pro hac vice 25 CR 176, MMG, United States of America, against Luigi Mangione, defendant, ex pursuant to Rule 1.3 of the local rules of the United States Courts for the Southern and Eastern Districts of New York. Paresh Patel hereby moves this court for an order for admission to practice pro hac vice to appear as special counsel for Luigi Mangione at the conference scheduled for January 9, 2026. I am in good standing of the bars of the states of Maryland, West Virginia and Washington, D.C., and there are no pending disciplinary proceedings against me in any state or federal court. I have never been convicted of a felony. I have never been censured, suspended, disbarred or denied admission or readmission by any court. I have attached the affidavit pursuant to Local Rule 1.3. Respectfully submitted. Applicant's signature, S. Paresh Patel. Applicant's name, Paresh Patel. Firm name, Federal Public Defender for the District of Maryland. Address, 6411 Ivy Lane, Suite 710 City State Zip, Greenbelt, Maryland 20770.
So this is another document of them hiring this person, but this is more so them sharing their credentials. As I am fit for the job, this is all of my credentials and all that here. I have redacted some things in this, like personal information, like phone numbers and stuff like that in this, because I don't want people to harass them, but I've just redacted some personal information in this document. But I'll pop it up on screen for you guys.
United States District Court, Southern District of New York, United States of America, against Luigi Mangione, Affidavit of Paresh Patel in support of application to be admitted pro hac vice 25 CR 176, MMG, Defendant, Paresh Patel, an attorney duly admitted in the districts of Maryland, West Virginia and the District of Columbia, affirms under the penalties of perjury as follows. 1. I am currently the appellate team lead at the Office of the Federal Public Defender for the District of Maryland. 2. I have been at the Federal Public Defender's Office since 2003. Before then, I worked as a staff attorney at the Public Defender Service in Washington, D.C. from 2001 to 2003, as a staff attorney at the Office of the Appellate Defender in New York in 1999 and, as a staff attorney at the Public Defender Service of West Virginia in Charleston and Charlestown FRM 1996 to 1998. 3. In 1999 to 2000, I clerked for the Honorable Ansel L. Haggerty of the United States District Court for the District of Oregon in Portland. 4. I earned my J.D. from American University in 1996, cum laude, and received my undergraduate degree from the University of Southern California in 1993, magna cum laude. 5. I am a member in good standing of the bars of the states of West Virginia, 1996, Maryland, 1997, and Washington, D.C., 1997. See Certificates of Good Standing attached. 6. There are no pending disciplinary proceedings against me in any state or federal court. 1. I have never been convicted of a felony. 2. I have never been censured, suspended, disbarred or denied admission or readmission by any court. 9. Wherefore, your affiant respectfully submits that he be permitted to appear pro hac vice in this case as special counsel for Luigi Mangione at the conference scheduled for January 9, 2026. I declare under penalty of perjury under the laws of the United States of America that the foregoing is true and correct. See 28 U.S.C. Section 1746. Paresh Patel sworn to before me on this lote day of January, 2026. Kimberis C. Willie Notary Public Kimberly C. Hawley Notary Public Prince George's County, Maryland. My commission expires August 17, 2027. Supreme Court of Maryland, Annapolis, MD Tatis 1A2S Certificate of Good Standing State of Maryland, SS, I, Gregory Hilton, Clerk of the Supreme Court of Maryland, do hereby certify that on the 25th day of June, 1997, Paresh Suman Patel, having first taken and subscribed the oath prescribed by the Constitution and laws of this state, was admitted as an attorney of said court, is now in good standing, and as such is entitled to practice law in any of the courts of said state, subject to the rules of court. This certificate of good standing is valid through the 6th day of March, 2026. Supreme cause in testimony whereof, I have hereunto set my hand as clerk, and affixed the seal of the Supreme Court of Maryland, this 5th day of January, 2026. Clerk of the Supreme Court of Maryland, West Virginia State Bar Certificate of Good Standing Paresh S. Patel, WVSB ID 7212. This is to certify that, according to the records of the West Virginia State Bar, Paresh S. Patel, of Greenbelt, MD, was admitted to practice law by the Supreme Court of Appeals of WV on September 30, 1996. According to the records of the West Virginia State Bar, as of January 5, 2026, Paresh S. Patel is currently an inactive attorney member in good standing with the West Virginia State Bar. Tanya Mary Jane Pickens, Esquire Executive Director, the West Virginia State Bar, on behalf of Julio A. Castillo, Clerk of the District of Columbia Court of Appeals, the District of Columbia Bar does hereby certify that Paresh S. Patel was duly qualified and admitted on April 4, 1997 as an attorney and counselor entitled to practice before this court, and is, on the date indicated below, an inactive member in good standing of this bar. In testimony whereof, I have hereunto subscribed my name and affixed the seal of this court at the City of Washington, D.C., on January 5, 2026. Kilakai S. Alto A. Castillo, Clerk of the Court, issued by David Chu, Director, Membership District of Columbia Bar. Membership. For questions or concerns, please contact the DC Bar Membership Office.
And this document is just them confirming, yes, they will be there working for Luigi Mangione's legal team on the 9th of January 2026. And I have redacted phone numbers and personal information in this document just because I don't want them to be harassed or anything like that. So I'll pop it up on screen for you guys.
United States District Court, Southern District of New York. Ex order granting motion for admission pro hac vice 25 CR 176, MMG, United States of America, against Luigi Mangione, defendant. Ex-applicant has declared that he is a member in good standing of the bars of the states of Maryland, West Virginia and Washington, D.C., and that his contact information is as follows: applicant's name, Paresh Patel, firm name, Federal Public Defender for the District of Maryland, address 6411 Ivy Lane, Suite 710, City State Zip, Greenbelt, Maryland 20770. Email, applicant having requested admission pro hac vice to appear for Luigi Mangione as special counsel at the conference presently scheduled for January 9, 2026. ITIS hereby ordered that applicant is admitted to appear pro hac vice at the conference scheduled for January 9, 2026 in the above captioned case in the United States District Court for the Southern District of New York. All attorneys appearing before this court are subject to the local rules of this court, including the rules governing discipline of attorneys. Dated, New York, January 2026. United States District Judge.
Here are some more screenshots from courtlistener.com. Pop them up on screen for you guys.
January 6, 2026. Notice regarding deficient motion to appear pro hac vice. January 6, 2026. Notice regarding deficient motion to appear pro hac vice. Notice as to Luigi Nicholas Mangione to refile document number 80. Motion for Paresh Patel to appear pro hac vice as special counsel at the conference on January 9, 2026. Motion and supporting papers to be reviewed by Clerk's office staff. The filing is deficient for the following reason: S. Missing certificate of good standing from Supreme Court of West Virginia. Motion must have a wet signature if filing using another individual's PACER account. Refile the motion as a motion to appear pro hac vice. Attach the correct signed PDF. Select the correct name filer/filers. Attach valid certificates of good standing issued within the past 30 days. Attach proposed order. RJU.
7th of January 2026. A couple of documents came out on this day. Basically, all those documents I showed you beforehand, basically all those documents have been filed on this day officially. I won't pop them up on screen for you guys. Exactly the same. The only difference is they've just been officially filed. That's the only difference. So this is a supplemental letter. Basically them requesting, can we have more time so we can have our arguments ready for January 9th, 2026. I'll pop it up on screen for you guys.
January 7th, 2026 by ECF Hon, Margaret M. Garnett, U.S. District Judge, U.S. Courthouse 40 Foley Square, New York, NY 10007 Re, U.S. v. Mangione 25 CR 176, MMG. Dear Judge Garnett, we write to provide the court with supplemental authority in support of our argument that even if the federal stalking statute is found to be divisible, subsection A of the stalking and cyber stalking statutes, 18 U.S.C. 2261A, 1, and 2261A, 2A, fails to qualify as a crime of violence because it can be committed without a purposeful or knowing threat of physical force. First, the defense points the court's attention to the pre-2013 version of the cyber-stalking statute, which, in relevant part, explicitly criminalized the intent to place a person in reasonable fear of the death of or serious bodily injury. 18 U.S.C. Section 2261A, 2b, 2006, emphasis added. In stark contrast, the current version of the stalking, 18 U.S.C. 2261A, 1a, and cyber stalking, 18 U.S.C. Section 2261A, 2a, statutes attaches no such mens rea to the reasonable fear of death of or serious bodily injury requirement. Instead, the current version of the statutes merely requires that the defendant engage in conduct that places the stalking victim in reasonable fear of the death of or serious bodily injury, i.d. This contrast between the old and current version of the statutes demonstrates that Congress knew how to write a statute that attached an intentional mens rea to the reasonable fear of death or serious bodily provision, and in fact, did so in a previous version, but consciously chose not to do so in the current version of the statutes that apply to Mr. Mangione. This is strong evidence that the current version of the statutes do not require the defendant to intentionally place a person in reasonable fear of death or serious bodily injury. Second, the defense points the court's attention to United States v. Fleury, 20F, 4th 1353, 11th C 2021, which reinforces that subsection A of the stalking and cyber-stalking statutes do not require a defendant to intentionally place a person in reasonable fear of death or serious bodily injury. Specifically, in Fleury, the defendant argued that the district court erred when on a cyber-stalking charge, 18 U.S.C. Section 2261A, 2b, it failed to give a jury instruction requiring a finding that the defendant intended the recipient to feel threatened, id. At 1371, the defendant argued that the court was wrong in failing to do so because it hinged criminal liability on how a reasonable person would view the messages rather than on subjective intent of the sender of those messages. The defendant, in violation of the Supreme Court's decision in Ellis v. United States, 575 U.S. 723, 2015, id. But the 11th Circuit rejected the defendant's argument, finding that there was no subjective intent to threaten required under the cyber-stalking statute. We find no error in the instruction provided to the jury. The district court properly declined to instruct the jury that the government had to prove Fleury's subjective intent to communicate a true threat to convict him of cyber-stalking under 18 U.S.C. Section 2261A, 2b. Fleury relies in vain on Ellis, where the Supreme Court read a mens rea requirement into a statute that lacked any center element, the transmission of interstate threats under 18 U.S.C. 875, c. No similar problem exists here because the cyber-stalking statute required proof that the defendant acted with the intent to harass or intimidate. See 18 U.S.C. Section 2261A, 2. Because the plain language of Section 2261A, 2, establishes a mens rea requirement sufficient to separate wrongful conduct from otherwise innocent conduct. Ellis, 575 U.S. at 736, 135 S. CT 2001. It was not reversible error for the district court to decline to impose an additional, subjective intent requirement for the jury to convict Fleury of cyber-stalking. The jury was instructed on the mens rea element, subjective intent to harass or intimidate, that Fleury must have had while communicating true threats. The jury found the government proved the requisite mental state beyond a reasonable doubt. Fleury cites no case law for his position that, even when a statute contains an express mental state requirement, the district court should read an additional mens rea requirement into the text, nor does such a position make sense. Fleury, 20F, 4th at 1371, 1372. See United States v. Dennis, 132F, 4th 214, 229, 2DC 2025, approvingly citing Fleury. Although Fleury involved a charge under the emotional distress subsection of the cyber-stalking statute, 18 U.S.C. Section 2261A, 2b, b. The 11th Circuit's ruling equally applies to the reasonable fear of injury subsection A, of the cyber stalking and stalking statutes, 18 U.S.C. 2261a, 1a, and 2261a, 2. This is so because just like the emotional distress subsection A also requires an intent to harass. Therefore, no further intentional mens rea is necessary to separate wrongful conduct from otherwise innocent conduct. Ellenis, 575 U.S. at 736. In short, no part of either the cyber stalking statute or the stalking statute requires an intentional threat of physical force. Thus, they both fail to qualify as crimes of violence. Thank you for your consideration of this letter. Respectfully submitted, Avraham C. Moskowitz, Elon Schulman, Christopher Neff, Moskowitz, Colson, Ginsberg, Ann Schulman, Karen Friedman, Anafilo, Mark Anafilo, Jacob Kaplan, Anafilo, Intrator LLP, Paresh, Patel, Special Counsel.
Hi, it's voiceover me. So I have no idea why I'm editing this video. I could not find the little bit where I say this is the document I'm talking about with the document I'm talking about here. I generally just cannot find it, so I think I must have forgot to say the title when I was filming on the day. But anyway, this next document I'm going to show you guys, it is the letter from the United States government addressed to Judge Garnett. So I'll pop it up on the screen for you guys.
January 7th, 2026 via ECF Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, 10007 Re, United States vs. Luigi Nicholas Mangione, 25 CR 176, MMG, Dear Judge Garnett, in accordance with the Court's December 31, 2025 Order, DKT, Number 79, the government respectfully submits this reply to respond to arguments the defendant raised for the first time in his reply brief, DKT, Number 76. Specifically, the government addresses the defendant's contention that the Attorney General's prior employment with Ballard Partners created a conflict of interest requiring recusal and that the Attorney General's failure to recuse herself violated the defendant's due process rights. For the reasons set forth below, these arguments are meritless. The defendant fails to identify a conflict or duty of recusal as a threshold matter. The defendant's description of the Attorney General's financial relationship with Ballard Partners is incomplete and misleading. The defendant quotes from the Attorney General's publicly filed financial disclosure form, in which the Attorney General states that she will continue to participate in a Ballard Partners defined contribution plan, DEF, reply at 3. He then asserts that she continues to profit from Ballard's connection to United Health Group, UHG, inviting the court to believe that the Attorney General stands to benefit from Ballard's current UHG lobbying revenue, DEF, reply at 1, 4. But the defendant omits critical language from the financial disclosure report, which makes clear that Ballard will not make further contributions after my separation to the defined contribution plan. That omission creates the misimpression that the Attorney General stands to profit from Ballard's ongoing representation of UHG, DEF, reply at 4, when in fact she disclosed that Ballard would make no further contributions to her plan upon her confirmation by the Senate and after she left that firm. There is nothing in the Attorney General's financial disclosure form that suggests receipt of any ongoing income, distributions, partnership draws, or remuneration from Ballard Partners in one Attorney General Pam Bondi's public financial disclosure report, at 5, January 3, 2025, https://extab s2.oj.gov/201/president/nsf/pass+index/abf60cd8ec97bbb 585,250,c150,032 dcb2 $file bondi %2c% 20 pam %20% 20 final 278 pdf any form. According to the disclosure form, the Attorney General holds a standard 401(k) account reflecting past, fully earned compensation to which Ballard has agreed not to make additional post-separation contributions. The defendant's narrative collapses under the weight of his own assumptions, because a financial conflict theory requires a demonstrable financial benefit tethered to the litigation. Where no present or future financial gain exists, there is no conflict. Therefore, because the defendant is unable to identify any pecuniary benefit to the Attorney General, his conflict of interest claim cannot stand as a matter of law. See Wright v. United States, 732 F, 2D 1048, 1058, 2D C 1984, finding no due process violation where prosecutors were not utilizing the criminal process to advance their own pecuniary interests. United States v. Gerrans, 752 F sub 3D 1120, 1127, ND Cal 2024. No due process violation where defendant's conflict of interest claim does not reveal a fundamental defect which inherently results in a complete miscarriage of justice or an omission inconsistent with the rudimentary demands of fair procedures. Quoting Wright, 732 F, 2D at 1057, Klein v. Jones, number 85 Civ 3685, 1986 WL 14596, at Star 10, EDNY October 22, 1986, no due process violation where defendant was unable to demonstrate that prosecutor had an actual pecuniary link to the outcome of this litigation. Similarly misleading is the defendant's characterization of the Attorney General's January 14, 2025 ethics letter, Def. Reply at 4.5. The defendant claims that the Attorney General vowed not to personally and substantially involve herself in any matter involving a client of Ballard Partners for a year after her Senate confirmation, and then accuses her of violating that supposed vow by acting in this case. ID, at 5. However, that is not what the letter says. The Attorney General committed not to participate for 1 year after her resignation from Ballard Partners in any matter in which Ballard Partners, or a client of Ballard Partners, was a party. Absent authorization under 5 CFR Section 2635.502, D2 neither UHG, nor United Healthcare, UHC, nor Ballard Partners is a party in this criminal case, and therefore the Attorney General had no ethical, statutory, or constitutional obligation to recuse herself on the basis of those entities' interests. Any collateral reputational or emotional interest those companies may have in the outcome does not transform them into parties or entities whose fortunes are so intertwined with the Attorney General's personal finances as to trigger a constitutional or ethical duty to recuse. The defendant's assertion that the Attorney General vowed not to participate in any matter involving a client of her former firm, regardless of party status, is inaccurate. The defendant fails to identify any statutorily based conflict or duty of recusal. Tellingly, the defendant does not even cite, let alone attempt to satisfy, the governing statutory standard for federal conflicts of interest. See 18 U.S.C. Section 208. Under Section 208, a prosecutor may not participate in a judicial proceeding in which he or she has a pecuniary interest. See Young v. United States ex rel. Vuitton et Fils S.A., 481 U.S. 787, 803, 1987, citing 18 U.S.C. Section 208. The defendant fails to invoke Section 208, because he cannot do what the statute requires, identify any concrete, non-speculative financial benefit the Attorney General stands to gain from this prosecution or from a capital outcome in this case. That omission underscores that his theory rests on insinuation, not on a cognizable pecuniary interest within the meaning of Section 208. Courts applying Section 208 confirm that such a conflict cannot be premised on the kind of conjectural, 2 ethics letter, at 2, January 14, 2025, https://extap.s2.oj.gov/201/president NSF, PARS plus index, FC3B6F6F496E257B8522F344% 24 file/Bondi, %20 PAM, %20 20 final EAPDF. Attenuated interest the defendant posits here, a prosecutor, like a judge, cannot be disqualified on the basis of a financial interest that is too remote, insubstantial, or speculative to create an actual or potential conflict of interest. United States v. Farrell, 115 F sub 3D 746, 756, SDW VAR 2015, finding no violation of Section 208 or due process despite pendency of class action lawsuit in which prosecutors were putative members. Likewise, there is no Section 208 conflict on the basis of remote, contingent, indirect or speculative interests. Scott v. Metro Health Company, 234 FAPP X 341, 357, 6th 2007, nor is Section 208 violated where the alleged tie is as indirect as a prosecutor's spouse working at a law firm that represents a non-party insurer litigating against the defendant. See United States v. Tierney, 947 F. 2D 854, 864, 8th 1991, finding no Section 208 violation where prosecutor's husband worked at a law firm representing an insurance company that sued the defendant. The defendant's inability to identify any present or future financial benefit defeats his claim under both due process principles and Section 208. The defendant fails to demonstrate any influence on the death authorization decision, even accepting the false assumption that the Attorney General received an ongoing financial benefit from her former firm. The defendant still has not shown the Attorney General's decision to authorize the death penalty in this case was influenced in any way by this purported benefit. The defendant identifies no communication from Ballard, UHC, or UHG to the Attorney General or department decision makers about whether to seek capital charges, which statutory aggravators to allege, or how to structure the notice of intent to seek the death penalty, nor has the defendant attempted to articulate how the nature of the defendant's sentence could financially benefit the Attorney General. There is simply no factual basis for the assertion that outside corporate interests influenced the Attorney General's charging decision in any fashion. The defendant's insinuations otherwise rest on an inaccurate financial narrative. The defendant errs in analogizing this case to Marshall v. Jericho, Incorporated, 446 U.S. 238, 1980. Marshall addressed whether a cost reimbursement mechanism under the Fair Labor Standards Act created an unconstitutional risk that agency civil penalty assessments would be inflated to fund enforcement operations. ID, at 24344. The Supreme Court held the scheme constitutional because no official personally profited, any institutional benefit was too remote, and the adjudicator at the administrative hearing, not the enforcement official, served as the neutral decision-maker. ID, at 250-51. Here, unlike in Marshall, the Attorney General is not operating under a statutory scheme that reimburses her office based on penalties she assesses, nor is she acting in a quasi-adjudicative role. ID, at 243. Indeed, the defendant has not articulated, and the government cannot conceive, of a basis to believe that seeking the death penalty in a murder case would inure to the financial benefit of UHG-UHC, or Ballard, much less the Attorney General. The defendant's reliance on Marshall attempts to stretch a case about administrative budgetary reimbursement for civil fines into the context of federal capital charging discretion, where the decision is guided by an internal DOJ review process and where no decision in this litigation could yield any personal or institutional financial gain. Accordingly, Marshall does not govern capital authorization decisions made through the Dodge's established protocol, and provides no basis to infer bias, require recusal, or strike the notice of intent. Even so, the holding in Marshall is instructive, while noting that rigid standards of neutrality cannot be the same for a prosecutor as for judges. The court found that a due process problem arises only where there is a realistic possibility the decision-maker's judgment will be distorted by a personal or institutional interest. ID, at 250. Here, the Attorney General authorized capital charges pursuant to the Justice Manual's Capital Case Protocol, a multi-layered review process. The only financial interest the defendant identifies, a frozen retirement plan reflecting past, fully earned compensation with no new post-separation contributions, is not the type of present or prospective economic incentive contemplated in Marshall. The defendant fails to demonstrate actual prejudice. The defendant argues that the Attorney General's prior employment with Ballard Partners, combined with purported public statements, requires the court to dismiss the indictment or strike the government's notice of intent. But the defendant's conflict narrative, including his references to the Attorney General's former role at Ballard Partners, does not establish that her past employment has affected the integrity or fairness of this prosecution. The defendant instead relies on Local Criminal Rule 23.1d, asserting that its presumption of potential trial interference supplies a basis to dismiss the indictment or strike the notice of intent. The defendant's attempt to equate the presumption of prejudice in Local Rule 23.1d with the actual prejudice required for dismissal or judicial override of an executive charging decision is legally incorrect. The Supreme Court has drawn a sharp distinction between publicity that may violate professional conduct standards and the far more demanding showing required to upset a grand jury determination or prosecutorial discretion under the Constitution. For example, in Bank of Nova Scotia v. United States, 487 U.S. 250, 263, 1988, the court held that dismissal of an indictment requires proof that misconduct substantially influenced the grand jury's decision to indict or leaves grave doubt that the decision was free from such influence. The defendant fails to meet this exacting standard because a local rule's ex-ante presumption about the risk of publicity cannot substitute for the ex-post record-based inquiry required by Bank of Nova Scotia. The local rule's presumption is a professional prophylaxis, not a constitutional evidentiary standard. Simply put, Local Rule 23.1 allows courts to regulate attorneys' speech to protect trial fairness. It does not authorize the judicial remedies the defendant seeks here. See, for example, Lauro v. Charles, 219 F, 3D 202, pages 209-10, 2DC 2000, condemning a staged perp walk in the civil context but not treating it as grounds for dismissal of criminal charges. Nor can the defendant transform the rule's professional speech restrictions into proof that a criminal proceeding was constitutionally tainted. The rule's presumption addresses the likelihood of potential interference, not proof that charging or grand jury judgment was actually compromised. Notably, the defendant fails to identify a single federal case in which any court has dismissed an indictment or struck a notice of intent to seek the death penalty based on Local Rule 23.1, underscoring that his requested remedy has no support in precedent. Moreover, as the defendant himself concedes, a district court's authority to dismiss an indictment to eliminate prejudice or deter official misconduct is narrowly circumscribed and applies only where the misconduct amounts to a violation of one of those few clear rules which were carefully drafted by the Supreme Court and by Congress. Def. Opening BR, at 30, DKT, number 51, quoting United States v. Silva, 103 F sub 3D 370, 376, SDNY 2015, that concession defeats his own argument. The defendant acknowledges that only a carefully drafted Supreme Court rule or act of Congress can supply the predicate for dismissal, yet Local Rule 23.1 is neither. It is a professional conduct rule governing attorney's speech, not a constitutional or statutory command enacted by Congress or prescribed by the Supreme Court. The defendant's position therefore contradicts the very limitation he accepts. If the court's authority to dismiss is triggered only by violation of one of the few clear Supreme Court or congressional rules, then dismissal or striking capital authorization cannot rest on a local attorney's speech rule that Congress did not enact and the Supreme Court did not prescribe. The defendant's theory thus fails on its own terms, because it seeks a remedy that is foreclosed by the narrow, record-based standard of dismissal he concedes governs the court's authority. The defendant relies heavily on United States v. Lopez-Macias, 522 F, 3D 150, 1st C 2008, to argue that the court should strike the government's notice of intent. Def. Reply at 1416. However, the defendant's reliance on Lopez-Macias begins with a fundamental error. It mischaracterizes the First Circuit's holding, which in fact vacated, not affirmed, the district court's order striking the government's notice of intent. Def. Reply at 14, describing the First Circuit's holding as requiring a lesser degree of prejudice to justify striking a notice of intent. Contrary to the defendant's suggestion, the First Circuit's reversal of the district court's order striking the government's notice of intent was based on the government's failure to comply with a local rule and the defendant's claim that they lacked a meaningful opportunity to present mitigation before capital authorization. The same claims the defendant makes here. 522 F, 3D at 151-55. The First Circuit did so because of the District Court's failure to identify actual prejudice, ID, at 154. Here, the District Court suggested no actual, let alone structural, prejudice, citing Bank of Nova Scotia, 487 U.S. at 257. The defendant seizes on the panel's passing reference to some prejudice to imply a relaxed dismissal standard, but that phrase appears only in non-binding dicta, not the court's reasoning or judgment, and the panel did not purport to alter the constitutional rule governing remedies to grand jury irregularities. The court's reference to some prejudice was offered in the context of appellate narration, not a doctrinal reformulation, and it was not intended to modify the controlling constitutional threshold, ID, at 158-59. In fact, the First Circuit repeatedly referenced and relied on the standard set forth Bank of Nova Scotia, ID, at 157. The defendant's arguments fare no better under the presumed prejudice standard in Skilling v. United States, 561 U.S. 358, pages 379-81, 2010. Skilling makes clear that presumed prejudice attends only the extreme case, and arises only where publicity so saturates the proceedings that the courthouse is utterly corrupted or bedlam reigned, conditions not present here. 561 U.S. at 380-81. The court further stressed that prominence does not necessarily produce prejudice, and juror impartiality, we have reiterated, does not require ignorance, ID, at 381, emphasis in original. Here, the defendant offers no showing that the proceedings have occurred in an atmosphere incapable of being cured through voir dire, juror questionnaires, or trial management. Accordingly, the defendant's claims fail to meet both the record-based actual prejudice standard of Bank of Nova Scotia and the narrow, extraordinary, presumed prejudice threshold of Skilling. The court should reject the defendant's effort to transform Local Rule 23.1 into a constitutional indictment veto or a capital notice striking rule, and instead rely on the established safeguards designed to address publicity-related risk through searching voir dire and careful trial management. Skilling, 561 U.S. at 384, 425-26, Newman v. Virginia, 500 U.S. 415, 427, 1991, United States v. Griffin, No. 94 CR 631, AGS, 1996 WL 140073, at Star 1, SDNY March 27, 1996. Respectfully submitted, Sean S. Buckley, attorney for the United States Attorney acting under authority conferred by 28 U.S.C. Section 515 by S. Dominic A. Gentile / June Zhang Alexandra Messiter, Thomas John Wright, Assistant United States Attorneys 212-637-2200.
This document, they are arguing basically what was brought up on the 31st of December 2025 of dual process, because literally Luigi Mangione can't be in two places at the exact same time. Like, no one can. We all wish we could, but we can't, and that's literally what's going on here. So this I found incredibly interesting. So basically, Pam Bondi, the person who's also the district attorney as well, she was the one who put the death penalty on Luigi Mangione because she said so. Don't know why. Maybe she wanted to look good in Donald Trump's eyes. Like, why do you want to do that? But anyway, and like we already know, she is a lobbyist for United Healthcare, and that was a big thing, wasn't it? And it comes out here, she actually profits off United Healthcare, adding another layer to this. And literally, I have in my notes, I was like, of course she fucking profits off this from United Healthcare, adding another layer to this entire thing. So, and she profit offs from United Healthcare, and also with Ballard Partners, they also profit off from the United Healthcare, and they have connections with Pam Bondi, and that's how they can both profit off United Healthcare. And basically the document that is meant for the public, for everyone to see, once she left that company that works with the United Healthcare for being a lobbyist, that is meant a document that releases to the public for everyone to see of the income and how much she profits off that. She did not have that written down in that document whatsoever for everyone to see once she left that company still profiting off United Healthcare once she left, and of course fucking money's involved this entire thing. And she basically made $401k even after she left that company a year ago that works with United Healthcare, profiting off them literally when she doesn't work for them anymore. Also brought up in this document as well, apparently Pam Bondi said she wrote a letter saying she will not profit or get involved with United Healthcare. She left a year ago. In reality, that letter does not say that whatsoever. Pam Bondi is claiming, in reality, like we already know, she is involved. She is sticking all the fingers in all the pies in Luigi Mangione's case because of this. She's still earning a income from them. In this document, they also bring up a little example saying a judge is not meant to be involved, say with a company, and then also be part of their case, and that's exactly what Pam Bondi is doing, like we already know. And like I said before, she is involved, like she was a lobbyist for United Healthcare and also profiting off them, but she still decides to get involved. But in reality, they're not meant to be involved whatsoever in something like this if they are already a part of it and involved with the company that the lawsuit etc. is going on with them, if that makes sense. Apparently in the same letter, Pam Bondi said she's not involved with the United Healthcare, not profiting off them. She did not get any contact from United Healthcare or even allowed to put the death penalty against Luigi Mangione. Yeah, fucking bullshit, I say. And they also bring up in the document they basically failed to prove what Pam Bondi was not influenced by the United Healthcare whatsoever to put the death penalty on Luigi Mangione, and they should just throw out the entire indictment altogether just because of that reason underneath the Rule 23.1. Also, it's really nice they actually do the little description of like what law 23.1 means instead of me, running off and looking up for you guys. So I'll pop what that little rule means up on screen for you guys. It's pretty helpful they put that in that document. So thanks. I'll put it up on the screen for you guys, so what that little rule means.
Simply put, Local Rule 23.1 allows courts to regulate attorneys' speech to protect trial fairness. It does not authorize the judicial remedies the defendant seeks here. See, for example, Laura versus Charles, 219 F. 3D 202, pages 209 to 10, 2DC 2000, condemning a staged perp walk in the civil context, but not treating it as grounds for dismissal of criminal charges. Nor can the defendant transform the rule's professional speech restrictions into proof that a criminal proceeding was constitutionally tainted. The rule's presumption addresses the likelihood of potential interference, not proof that charging or grand jury judgment was actually compromised. Notably, the defendant fails to identify a single federal case in which any court has dismissed an indictment or struck a notice of intent to seek the death penalty based on Local Rule 23.1, underscoring that his requested remedy has no support in precedent.
And basically that rule is put in place so basically there is fairness going on in the court, so basically a judge will not be biased towards someone because they're already working with that specific company. So say someone's suing a company because, I don't know, injury or something or whatever, and that judge is part of that company, they would rule more so in the company's favor because they profit off it or they're a partner with them, etc., compared to the person who is not part of that whatsoever. So that's why this rule is a thing. Hopefully I explained that quite nicely, actually. I do not know. Also, I think right now Pam Bondi is a bit in hot water, the world's just starting to hate her now. I think it's because of the Epstein files and she won't release that to the public for some reason. I only hear about that, but I'm glad more people are hating her now compared to just the people in the Luigi Mangione case and the poor victims in the Epstein files. Now everyone's hating her. Can't believe a person who is a woman who will happily keep that away from the public of knowing of the disgusting actions of disgusting monstrous men. How can you be a woman and be okay with that? And we're not going over that today. Other people have probably talked about that. So this is another document that came out on this day. So this is a motion to lead a supplemental letter. So I'll pop it up on screen for you guys.
January 7th, 2026 by ECF Hon, Margaret M. Garnett, U.S. District Judge, U.S. Courthouse 40 Foley Square, New York, NY 10007 Re, U.S. v. Mangione 25 CR 176, MMG. Dear Judge Garnett, this letter is respectfully submitted on behalf of the defendant, Luigi Mangione, to request permission to file a brief supplemental letter discussing additional authorities relating to the oral argument scheduled to take place before Your Honor on January 9, 2026. Although the authorities discussed in the letter are not new cases, their relevance and significance became apparent to counsel during preparation for oral argument, and we therefore wanted to provide them to the court and the government in advance of the argument so that all of the parties will be prepared to discuss them. A copy of our proposed letter is attached hereto as Exhibit A. Thank you in advance for your consideration of this request. Respectfully submitted, Avraham C. Moskowitz, Elon Schulman, Christopher Neff, Moskowitz, Colson, Ginsberg, Ann Schulman, Karen Friedman, Anafilo, Mark Anafilo, Jacob Kaplan, Anafilo, Intrator LLP, Paresh, Patel, Special Counsel.
This document is just basically saying, hey, can we add more things to our oral argument? Basically, even if this isn't new news, this is still news that came out on. This isn't new news, but it's still very much news, and they want everyone to know about it and be prepared for it for January 9th, 2026. Here are some more screenshots from courtlistener.com. Pop them up on screen for you guys.
January 7th, 2026 Notice regarding Pro Hac Vice Motion. January 7th, 2026 Notice regarding Pro Hac Vice Motion. Regarding Document Number 82 Motion for Paresh Patel to appear Pro Hac Vice as Special Counsel at the conference on January 9, 2026. Motion and supporting papers to be reviewed by Clerk's office staff. The document has been reviewed and there are no deficiencies. RJU.
The 8th of January 2026. Basically, a letter was submitted to Judge Garnett from the United States government about the suppression of Luigi Mangione's backpack and also his statements and also fake ID he handed to the Altoona police force. So I'll pop it up on the screen for you guys.
January 8th. 2026 via ECF Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, New York, 10007 Re, United States v. Luigi Nicholas Mangione, 25 CR 176, MMG. Dear Judge Garnett, the government writes in response to Defendant Luigi Mangione's request for an evidentiary hearing regarding his motion to suppress the contents of his backpack and, in particular, his argument that a hearing is required to address whether the inventory procedures would have inevitably led to discovery of the contents of Mr. Mangione's journal, DKT 81 at 3. The argument the defendant now makes, that the contents of his notebook should be suppressed because reviewing such materials exceeds the scope of an inventory search, is asserted nowhere in his moving or reply papers and, accordingly, is waived. In any event, the argument is misplaced, and no evidentiary hearing on this issue is warranted, because the government does not rely on the inventory search or inevitable discovery doctrines with regard to the contents of the defendant's notebook. Rather, the government searched the contents of the defendant's notebook pursuant to a judicially authorized search warrant that expressly covered, among other things, handwritten materials, including notebook entries, contained within the defendant's backpack. To the extent that the defendant now seeks to challenge the validity of the government's warrant, an argument the defendant similarly did not make in either his moving or reply papers, that argument would also fail on the merits because the warrant, which disclosed the initial search of the defendant's backpack by the Altoona Police Department, was supported by ample probable cause. In particular, the defendant now argues that the warrant lacked probable cause because the application itself relied, in part, on items found in the defendant's backpack, but that argument does not apply to the notebook's contents, which were not relied upon in the warrant application. Accordingly, for the reasons stated herein and previously set forth by the government in the parties' joint filing, no evidentiary hearing is required in order to resolve the defendant's motion to suppress. Respectfully submitted, Sean S. Buckley, Attorney for the United States Attorney acting under authority conferred by 28 U.S.C. Section 515 by S/Dominic A. Gentile, June Ziang, Alexandra S. Messiter, Thomas John Wright, Assistant United States Attorneys, 212-637, 2567 per 2295/2544 per 2289 cc, Karen Friedman Anafilo, ESQ, via email, Mark Anafilo, ESQ, via email, Jacob Kaplan, ESQ, via email, Avi Moskowitz, ESQ, via email.
So basically, this is the United States government's response to Karen Akafilo's response to their response. Sometimes it sounds like that, it sounds very childish. It's like it's a response to a response to a response. Sometimes it's like that, sometimes a little bit of a tongue twister. Basically, in this document, they argue and say, no, we do not need a evidentiary hearing for the suppression of Luigi Mangione's backpack, because what the Altoona police did is totally fine. They did nothing wrong, but in reality, they definitely did. So basically, they argue they don't need to have a evidentiary hearing that Karen Akafilo is requesting for Luigi Mangione for this to happen, to be suppressed, but the prosecution and the United States government are arguing, saying, no, we don't need that. It was totally fine, when it wasn't. So this I found interesting, they brought up in this document. Basically, they said the search warrant that they got for Luigi Mangione's backpack does not give them access to read Luigi Mangione's notes that they found in his backpack, or even the notebook they found in his backpack. And I find that kind of interesting and doesn't really make sense. Like we already know, they originally got that search warrant so they could keep the alleged writing they found on Luigi Mangione, the notes they allegedly found in his backpack, and also the alleged notebook they found in his backpack, and that's why they got the search warrant. So it doesn't really make sense for them to say, no, the search warrant they got does not give them access to actually read that kind of stuff, and I find that very odd, I think, anyway, when they wanted that in the first place. But then the prosecution are saying, no, it does not give them access to that. It's a bit odd. Here are some more screenshots from courtlistener.com. I'll pop them up on screen for you guys.
January 8th, 2026 order granting 82 motion for Paresh Patel to appear pro hac vices to Luigi Nicholas Mangione, 1. Signed by Judge Margaret M. Garnett on the 1st of August 2026. Garnet, Margaret, entered. The 1st of August 2026. January 8th, 2026 order on motion to appear pro hac vice. January 8th, 2026 sealed document. January 8th, 2026 order on motion for leave to file document. January 8th, 2026 order on motion for extension of time to file response/reply. January 8th, 2026 order granting 72 motion for extension of time to file response/reply as to Luigi Nicholas Mangione, 1. Signed by Judge Margaret M. Garnett on the 1st of August 2026. Garnet, Margaret, entered. The 1st of August 2026, main document. January 8th, 2026 order granting 84 motion for leave to file as to Luigi Nicholas Mangione, 1. Signed by Judge Margaret M. Garnett on the 1st of August 2026. Garnet, Margaret, entered. The 1st of August 2026, main document. January 8th, 2026 sealed document placed in vault. Jus, entered. The 1st of August 2026, main document.
The 9th of January 2026. So this day was very important. So basically, Luigi Mangione appeared in court again. And we did not get any photos like we saw in the December suppression hearing in Luigi Mangione's case, but we did get sketches on this day, and it does look like from the sketches we got, it does look like they did not let Luigi Mangione wear court approval clothing again. And sadly, on this day, we didn't really get much on this day, and this was like meant to be the really big thing on January 9th, 2026 of to get rid of the death penalty or not. The only thing that really happened on this day was them to reschedule another court date that would be on the 30th of January 2026. Kind of disappointing that happened. I remember when that was going on, it's like, oh my god, that's infuriating. Literally one of the biggest things to happen for, to get rid of the death penalty on someone or not was literally just not much happened. It's like, we'll do it another time. Like, that must have been incredibly frustrating for Luigi Mangione and his legal team for that to happen. Luckily, we do have a transcript what was said on this day. I will make it its own dedicated video just because it's insanely long, but I want to say a big thank you to this person on Reddit. They very kindly just put the entire transcript into a Google document for everyone to read, so thank you so much. I'm not sure if they run the Brian Thompson murder subreddit. It's mostly where I get my documents from, and then like a couple of other subs in Luigi Mangione's case. But I'm not sure if they run the sub or they are like partners or whatever. I don't understand the law behind things in Reddit. But that did come out a couple of weeks ago. But this is when it's meant to be happening, so very exciting. We got a transcript for this day. We are still waiting for the December suppression hearing transcripts. I know they're on the Free Luigi subreddit, but they're still not on the official website where you can read official transcripts in Luigi Mangione's case. They're still not there. I'm waiting for them to be there, so I'm still a little bit skeptical about those transcripts that were on the Free Luigi Mangione subreddit. No harsh words to that person who runs that sub. I'm just still a little bit skeptical about it, that's all. They're like not everywhere else, just that one sub, if that makes sense. If I'm wrong, please yell at me in the comments down below. There are some more screenshots from courtlistener.com. I'll pop them up on screen for you guys.
January 9th, 2026 minute entry for proceedings held before Judge Margaret M. Garnett. Status conference as to Luigi Nicholas Mangione held on the 1st of September 2026. Defendant appeared with attorney Avraham Moskowitz, Jacob Kaplan, Karen Anafilo and Mark Anafilo, Elin Schulman, Christopher Neff and Paresh Patel, AUSA Alexandra Messiter, Dominic Gentile, June Zhang and Thomas Wright present for the government. Court reporter present. Oral argument on defendant's motion to dismiss counts 3 and 4 was heard. Next status conference set for January 30th, 2026, at 11 a.m. Speedy trial time excluded until January 30th, 2026. Detention continued. Status conference set for the 30th of January 2026 at 11 a.m. before Judge Margaret M. Garnett, App. January 9th, 2026 status conference and util, set/reset hearings and util, terminate motions.
So, if you guys are like curious, because I realize my audience is mostly American, if you guys don't know what the word pop means like another word to put like in like Australian/British English. So that's why I say I'll pop it up on screen. Basically, I'm saying I'm putting up on screen. A little fact for you guys. The 12th of January 2026. This is a order filed. I'll pop it up on screen for you guys.
U.S. District Court Southern District of New York Notice of Electronic Filing. The following transaction was entered on the 1st of December 2026 at 8:21 a.m. EST and filed on the 1st of December 2026. Case name, case number, filer, USA vs. Mangione 125 CR 00176 MMG document number, 90, no document attached, docket text. Order as to Luigi Nicholas Mangione. On reflection, and considering both the arguments made by counsel at January 9th conference and the seriousness of the charges the defendant is facing, the court hereby orders the government to produce for a hearing an officer of the Altoona Police Department with sufficient authority and experience to testify about the established or standardized procedures in use by the department in December 2024 for securing, safeguarding, and, if applicable, inventorying the personal property of a person arrested in a public place. Because the inquiry will be focused on department procedures, the witness need not have had any personal involvement in the defendant's arrest. Given the very limited subject matter, the court expects the hearing to be brief. The government is further ordered to confer with defense counsel and their identified witness and proffer available dates and times in the next 2 weeks to the court. Finally, the government is further ordered to promptly provide the court with a copy of the affidavit in support of the federal search warrant, and any documents incorporated therein by reference. Signed by Judge Margaret M. Garnett on the 1st of December 2026, Garnett, Margaret 125 CR 00176 MMG1 notice has been electronically mailed to.
So this document I came across on Reddit. It looks like a screenshot from courtlistener.com, but I couldn't find it when I was looking there. But I do recommend to take this document with a little bit of skepticism just because of that reason, but it does say another court date that is scheduled for Luigi Mangione here. I'll pop it up on screen for you guys.
The 12th of January 2026. Two orders to Luigi Nicholas Mangione, on reflection, and considering both the arguments made by counsel at January 9th conference and the seriousness of the charges the defendant is facing, the court hereby orders the government to produce for a hearing an officer of the Altoona Police Department with sufficient authority and experience to testify about the established or standardized procedures in use by the department in December 2024 for securing, safeguarding, and, if applicable, inventorying the personal property of a person arrested in a public place. Because the inquiry will be focused on department procedures, the witness need not have had any personal involvement in the defendant's arrest. Given the very limited subject matter, the court expects the hearing to be brief. The government is further ordered to confer with defense counsel and their identified witness and proffer available dates and times in the next 2 weeks to the court. Finally, the government is further ordered to promptly provide the court with a copy of the affidavit in support of the federal search warrant, and any documents incorporated therein by reference. Signed by Judge Margaret M. Garnett on the 1st of December 2026. Garnet, Margaret, entered. The 1st of December 2026.
14th of January 2026. On this day, we only have some screenshots from courtlistener.com, so I'll pop them up on screen for you guys.
January 14th, 2026. Scheduling orders to Luigi Nicholas Mangione. The suppression hearing referenced in the court's January 12th order, DKT, number 90, will be held on Friday, January 23rd, 2026 at 11 a.m., in courtroom 110 of the Thurgood Marshall United States Courthouse, 40 Foley Square, New York, NY. The testimony will be limited to the topics identified in January 12th order. Signed by Judge Margaret M. Garnett on the 14th of January 2026. Garnet, Margaret, entered. The 14th of January 2026. Main document. January 14th, 2026. Scheduling order.
The 16th of January 2026. This is a official finding for the release of the January 9th, 2026 transcript to be released to the public. That's why I said earlier in the video saying yes, we have a transcript. This is when it was officially released to the public for everyone to read and enjoy. This is a letter from Karen Arcafillo, and I want to say a huge thank you to this person on Instagram. I would say your username, but I don't have any fucking idea how to say it. But huge thank you to this person who very kindly took screenshots and then just sent me the screenshots of this letter filed by Karen Arcafillo. I'm not going to use them because I do have access to this document. But I just want to say thank you for sending them to me. I do appreciate it. I'm noticing a lot more. A lot of you guys are like catching on. I don't get access to a lot of these documents in Luigi Mangione's case because I just do not live in the United States. I do appreciate it a lot. Even if some of the documents I do have access to, I do appreciate it a lot more than you think. It does help me out a lot more. So thank you all so much for like sending me documents or sending me links to documents. I do appreciate it so much. I think you guys are catching on. I don't get access a lot to some of the documents and I have to rely on Reddit, so thank you. I do appreciate it a lot more than you think, so huge thank you to you. So I'll pop the document up on screen for you guys.
January 19th, 2026 via ECF, the Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York. New York 10007 Re, United States v. Mangione, 25 CR 176, MMG. Dear Judge Garnett, this letter is respectfully submitted on behalf of the defendant Luigi Mangione, seeking permission to file the attached brief supplemental letter discussing an additional authority that was decided since our prior submissions and 4 days after oral argument on January 9, 2026. A copy of the proposed letter is attached here too. Thank you in advance for your consideration of this request. Respectfully submitted, Karen Friedman Anafilo Mark Anafilo Jacob Kaplan Anafilo Intrator LLP Avraham C. Moskowitz Elon Schulman Christopher Neff Moskowitz Colson Ginsburg and Schulman Paresh Patel Special Counsel CC, Gut Counsel, by ECF. January 19, 2026 via ECF, the Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York. New York 10007 Re, United States v. Mangione, 25 CR 176, MMG. Dear Judge Garnett, we write to provide the court with further supplemental authority in support of our argument that subsection A of the Stalking and Cyberstalking Statutes, 18 U.S.C. 2261A, 1a, and 2261A, 2, fails to qualify as a crime of violence under 18 U.S.C. section 924, c. 3, because it can be committed without a purposeful or knowing threat of physical force. Specifically, the defense points the court's attention to the Ninth Circuit's en banc decision in United States versus Gomez, F. 4th, 2026 WL 90274, 9th 6, January 13, 2026, en banc. In Gomez, the Ninth Circuit held that a California statute, Cal. Penal Code Section 245, 1, which criminalized assault upon another person with a deadly weapon or instrument, categorically fails to qualify as a crime of violence after Borden v. United States, 593 U.S. 420, 2021, because it can be committed with the reckless use of force. Gomez, 2026 WL 90274 at *67. In concluding as such, the en banc court rejected the government's argument that the statute requires the purposeful use of force, ID, at *6. Likewise, the court rejected the government's argument that the statute requires the knowing use of force, ID. In so doing, the court explained that under Borden's terms, knowledge is a very demanding standard under which a person must know with practical certainty, that a result is to follow from his actions, ID, at 7, quoting Borden, 593 U.S. at 426, internal quotation marks omitted, because the California assault statute does not require an intent to apply force or knowledge, with practical certainty, that an action will cause force to be applied to another. The Ninth Circuit held that the offense categorically fails to qualify as a crime of violence, ID, at *6. In getting there, the court reasoned, a person acts knowingly when he is aware that a result is practically certain to follow from his conduct, whatever his affirmative desire. Borden, 593 U.S. at 426, 141 S, CT 1817, plurality opinion, alteration in original, quoting Bailey, 444 U.S. at 404, 100 S, CT 624. The government argues that Section 245, 1, requires, at the very least, a knowing use of force, but such a reading is incompatible with the California Supreme Court's holding, recited above, that assault does not require a subjective awareness of the risk of injury the defendant has created. Williams, 111 Calorisa PTR, 2D 114, 29p, 3D at 204. While it is true that, as the government emphasizes, the California Supreme Court requires the Honorable Margaret M. Garnett, January 19, 2026, page 2 of 3.2, knowledge of the facts that make the action the type of act likely to result in harm, this does not equate to a subjective awareness that harm is practically certain to result. Borden, 593 U.S. at 426, 141 S, CT 1817, plurality opinion. Rather, as the California Supreme Court has explained, even a defendant who honestly believes that his act was not likely to result in a battery is still guilty of assault if a reasonable person, viewing the facts known to the defendant, would find that the act would directly, naturally and probably result in a battery. Williams, 111 Calorisa PTR, 2D 114, 29p, 3D at 203 N, 3. This falls far short of Borden's definition of knowledge. 5. Indeed, knowledge of the facts sufficient to establish that the act by its nature will probably result in force, ID, 111 Calorisa PTR, 2D 114, 29p, 3D at 204, is less culpable even than Borden's definition of recklessness, which requires conscious disregard of a substantial risk. 593 U.S. at 427, 141 S, CT 1817, plurality opinion, ID, at *7. In other words, the Ninth Circuit clarified that the California assault statute can be violated when there is a divergence in views between the defendant, who honestly believes that his acts are not putting the victim in fear of injury, and the victim, who reasonably fears physical injury from the defendant's actions. Under this divergence, the statute fails to satisfy Borden's purposeful or knowing mens rea requirement, id. In the same way, there is no purposeful or knowing threat of force required under subsection A of the stalking and cyberstalking statutes. Rather, for all the reasons discussed in our briefs, ECF number 59-2 at 2932 and ECF number 76 at 3237, in our letter of supplemental authority, ECF number 84-1, and in the hearing on January 9, 2025, these statutes are violated when a defendant unknowingly and unintentionally places a victim in reasonable fear of serious bodily injury or death. Subsection A criminalizes the same divergence in views between the defendant and the victim that disqualified the California assault statute as a crime of violence in Gomez. It necessarily follows that subsection also fails to qualify as a Section 924, c. crime of violence. The Honorable Margaret M. Garnett, January 19, 2026, page 3 of 33. Thank you for your consideration of this letter. Respectfully submitted, Karen Friedman, Anaphilo, Mark Anaphilo, Jacob Kaplan, Anaphilo, Intrator LLP, Avraham C. Moskowitz, Elon Schulman, Christopher Neff, Moskowitz, Colson, Ginsburg, and Schulman, Paresh, Patel, Special Counsel CC, Gut Counsel, by ECF.
Basically, this document is about some changes that was made 4 days after the 19th of January 2026 when Luigi Mangione appeared in court. That decision was made 4 days after that from someone higher up in Luigi Mangione's case to change some things. And interesting enough, they don't say what things that they want to change in this document that was made by someone higher up. It just says someone higher up have wanted to make some changes 4 days after that court appearance in Luigi Mangione's case. And they also bring up in this document, like we already know, they have the digital stalking charges put against Luigi Mangione, and like we already know, we discussed this quite heavily in the past in my last videos, mostly in December last year. Basically, with the stalking charges they are putting on Luigi Mangione, saying even the updated version of those stalking charges, they're trying to claim those stalking charges lead to violence 3 and 4 against Luigi Mangione, and in reality those charges do not fall underneath that category for those charges to be put on someone, and that's what they argue in this document a little bit. Again, we've talked about that a lot more heavily in my last couple of videos, mostly in December last year, where I talked about that quite a bit. They went into detail quite a bit there about it, but they bring it up here as well. The 20th of January 2026. So basically this is the letter from Karen Arcafilo about the decision that was made 4 days later after Luigi Mangione's appearance, January 9th, 2026, and the document that was a little bit about Pam Bondi. It was officially filed. Basically, I'll pop it up on screen for you guys.
IAECFTAGHON or a BLEMRGR at Unit ED Street at ESD Street CTJUDGESO at HRND Street CT of NEWY or K40FLEYSQ NEWY or K NY10007RE NIT ED Street at ES versus MNGONE 25CR176 MMG DER DGEGRN at THISL at ISRESPECTF LYSUB MIT EDONBEH Alpha of THEDFENDNTLUIGMNGONE SEEKNGPMESCONTO Philly THE at CHED BREFSUPPLEMENTAL at ODSCUSCNGN at DDON AL at H or at YTH at WSDECDEDCNCEO April SUB MESCONSNDF ODYS after all AL GUMENTONJNURY 9 2026 ACOPY of THEPROPOSEDL at RIAS at CHEDH or at OTH and KYOUAN at DVNCEF or YOOCONCD radio and of THISREQUE Saint ESPECTF LYSUB MIT ED KREN Friday EDM NAG NIFL OMCAG NIFL OJSCOB KAPL NAG NIFIL OINTRATERLLPAVREH MCMOSKO WIDZEL NSCHLM NCHRI Street OPH NFMOSKO WITZCOLSONGIN SBERG and SCHULM. ANPRESHP at LSPECLCOUNSLCC, GOVCOUNSL, BYECF.
23rd of January 2026. Luigi Mangione appeared in court again on this date, but some very important things did happen on this day. So basically court dates were just scheduled on this day. So basically jury selection was decided on September 8th, 2026, and the trial will be set on the trial will start on October 13th if the death penalty is not decided on, and if the death penalty is decided on, it would be on January 11th, 2027. But like we already know, the death penalty has been taken off the table for Luigi Mangione's case. Again, we will go over that when we get to it later on in the video. And also on this day, we do have a official transcript that came out 23rd of January 2026. That will be its own dedicated video. So again, I just want to put this here. We do have a official transcript on this day as well. Again, very exciting stuff. So we did get a document from the prosecutors that came out on this day, so I'll pop it up on screen for you guys.
January 23, 2026 via ECF and email Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, 10007 Re, United States versus Luigi Nicholas Mangione, 25 CR 176, MMG. Dear Judge Garnett, the government writes in connection with today's evidentiary hearing, specifically with regard to defense counsel's filing of two proposed defense exhibits late last night. Counsel seeks to admit the Altoona Police Department General Order 1.2 and a document titled Altoona Police Department Prisoner Log that appears to have been prepared by one of the Altoona officers who arrested the defendant in Altoona, Pennsylvania on December 9, 2024. The prisoner log. The government objects to any attempt by the defense to introduce the prisoner log as an exhibit or to cross-examine the government's witness, Deputy Chief Nathan Snyder, regarding that document. For one thing, the government expects Deputy Chief Snyder to testify that he was not present at the defendant's arrest on December 9, 2024 and was, in fact, out of town on that date. He will further testify that he had no involvement in the Altoona Police Department's investigation of the defendant and has not had any substantive conversations with the officers who participated in the defendant's arrest concerning their actions. That day, he has never previously seen the prisoner log. Accordingly, Deputy Chief Snyder has no personal knowledge of, and no basis to respond to questions concerning, the prisoner log or the specific conduct of any individual officer during the defendant's arrest. Moreover, the court expressly cabined the scope of today's proceeding to the Altoona Police Department's standardized procedures for securing, safeguarding, and inventorying the personal property of an individual arrested in a public place and, specifically, those procedures that were in effect in December 2024. The prisoner log relates, at most, to the actions of a particular officer on a particular day and falls well outside the limited purpose for which Deputy Chief Snyder is being called. Allowing cross-examination on that document would improperly expand the hearing into an examination of case-specific conduct by officers who are not witnesses and about matters beyond Deputy Chief Snyder's knowledge and that are irrelevant to the purpose of today's hearing. For these reasons, the government respectfully requests that the court preclude the defense from introducing the prisoner log and from attempting to cross-examine Deputy Chief Snyder regarding that document. Respectfully submitted, Sean S. Buckley, Attorney for the United States Attorney acting under authority conferred by 28 U.S.C. Section 515 by S/Dominic A. Gentile, June Ziang, Alexandra S. Messiter, Thomas John Wright, Assistant United States Attorneys, 212-637-2567 per 2295/2544 per 2289 cc. Counsel of Record, via ECF and email.
Basically, in this document, they talk about the prisoner log and also the transcript as well. In this document, they also bring up basically the prisoner log and also just use those two words. So I don't know if they just mean prisoner log and log as the same thing, or it's like two separate different things, but they keep bringing that up. Basically, they say, hey, this one officer that they want to ask questions for was not there on the day whatsoever. He was busy doing something else, so he shouldn't be questioned whatsoever because he's not there. Why are they going to be questioning him about the prisoner logs and also the logs? So they should not be able to question him whatsoever because he wasn't there. That's basically what this document is. Here are some more screenshots from courtlistener.com that came out on this day, so I'll pop them up on screen for you guys.
January 23rd, 2026 minute entry for proceedings held before Judge Margaret M. Garnett. Suppression hearing as to Luigi Nicholas Mangione held on the 23rd of January 2026. Defendant appeared with attorney Jacob Kaplan, Karen Anafilo and Mark Anafilo, Elin Schulman, Christopher Neff and Paresh Patel, AUSA Alexandra Messiter, Dominic Gentile, June Zhang and Thomas Wright present for the government. Court reporter present. Evidence entered. Testimony received. Detention continued. LNL, October 13, 2026 trial date for non-capital trial January 11, 2027 trial date for capital trial January 30, 2026 decision on counts 3 and 4, attached to capital punishment, should be made.
The 24th of January 2026. Basically, this is just a document, them submitting a letter saying, hey, can we submit a letter about basically what the prosecution said? That's basically what this document is, but I'll pop it up on screen for you guys anyway.
January 24th, 2026 via ECF, the Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, New York 10007 Re, United States v. Mangione, 25 CR 176, MMG, Dear Judge Garnett, this letter is respectfully submitted on behalf of the defendant Luigi Mangione, seeking permission to file the attached brief supplemental letter in response to the government's latest letter, dated January 23, 2026. A copy of the proposed letter is attached hereto. Thank you in advance for your consideration of this request. Respectfully submitted, Karen Friedman Anafilo, Mark Anafilo, Jacob Kaplan Anafilo, Intrator LLP, Avraham C. Moskowitz, Elin Schulman, Christopher Neff, Moskowitz, Colson, Ginsburg and Schulman, Paresh Patel, Special Counsel.
Hi, it's voice over me. I also apparently forgot to say the little title of what this document I was about to talk about here too. So this is the actual letter they actually sent. Before that document was them requesting can they send a letter, and this document is the actual letter they actually sent. Yeah, man, I'm off my game in this video. I forgot to say 2 titles already. Sorry about that, guys. Anyway, pop it up on screen for you guys.
January 24th, 2026 via ECF, the Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, New York 10007 Re, United States v. Mangione, 25 CR 176, MMG, Dear Judge Garnett, we write to respond to the government's latest letter dated January 23, 2026. In that letter, the government cites to a recent and published district court decision, United States v. Ceterum, 2026 WL 145348, SD FLA, January 20, 2026, in support of its argument that subsection A of the Stalking and Cyber-Stalking Statutes, 18 U.S.C. 2261A, 1a, and 2261A, 2, when death results, 18 U.S.C. Section 2261, b. 1, qualifies as a crime of violence under 18 U.S.C. 924, c. 3, in Ceterum, the district court held that subsection A of the cyber-stalking statute resulting in death cannot be committed with a threat of self-harm or with an unintentional and unknowing threat of physical force against another, id. at star 2-3. Specifically, the court reasoned that when a defendant engages in such conduct and accidental death results, he cannot reasonably foresee the death of another, therefore, no proximate cause is established between the defendant's actions and the resulting death. In turn, he cannot be lawfully convicted of cyber-stalking resulting in death, id. But this court must reject the holding in Ceterum because it squarely conflicts with Second Circuit precedent. In United States v. Felder, 993 F. 3D 57, 60-70, 2D C 2021, the Second Circuit expressly held that the death results provision for the federal carjacking statute, 18 U.S.C. section 2119, 3, solely requires a but for cause without any additional requirement of proximate cause. In other words, but for the defendant's actions, the death of the victim would not have occurred. In rejecting the government's proximate cause argument, the Second Circuit relied on a uniform all-of-circuit authority holding that an analogous offense of distributing drugs resulting in death, 21 U.S.C. section 841, 1, b, 1, c, only requires proof of but for cause, not proximate cause, between the distribution and the death. In other words, 841, b, does not require proof that the resulting death was reasonably foreseeable, id. At 69, the Second Circuit recognized that this precedent was discussing a death results from enhancement in the Controlled Substances Act, not the death results from enhancement in the federal carjacking statute, id. At 70. Nonetheless, the court held that this precedent applies as much in the latter context as in the former, id. And there is no good reason why the same would not hold true with respect to the identical death results provision in 18 U.S.C. section 2261, b. This court is bound by Felder, not a conflicting and published out-of-circuit district court decision. 1. Consistent with Felder, the Second Circuit has upheld a sentencing enhancement for death or bodily injury that resulted from a defendant's conduct, in the sense of but for causation, even though the defendant did not inflict the injury himself and was distant from the injury-causing event. For example, the Second Circuit held applicable a sentencing guidelines enhancement for bodily injury that resulted from a defendant's conduct where a bystander was shot by security guards fending off the defendant's robbery attempt. United States v. Molina, 106 F. 3D 1118, 1122-25, 2D C 1997. In Molina, the defendants tried to rob an armored car and shot at the car's guards. The guards returned fire and one of the guards' bullets hit a bystander's foot, id. At 1120. The circuit concluded that the bystander's injury had resulted from the defendant's conduct, even though the harm to the victim was the immediate result of a bullet fired from the weapon of a guard, because the defendant had put into motion a chain of events that contained the inevitable tragic result of the bullet being lodged in the bystander's foot, id. At 1123-24, quoting United States v. White, 979 F. 2D 539, 544-45, 7th C 1992. In the same way, death could result from stalking under subsection A when a defendant addicted to drugs threatens self-harm by putting a gun to his head upon demanding money for drugs, and in response, a nearby pedestrian, police officer, or the stalking victim herself attempts to wrestle a gun away from the defendant, and as a result, the gun misfires and kills a stalking victim, a police officer, or a nearby pedestrian. Likewise, death could result from cyber-stalking under subsection A when the addicted brother sends a barrage of texts to his sister, who is driving, threatening to kill himself because she won't give him money for drugs, and as a result, the sister gets distracted and runs a red light and a fatal accident occurs, killing her. Similarly, death could result from stalking under subsection A when the addicted brother, who is on a hike on a steep mountain with his sister, has no intent or knowledge of threatening or harming his sister, wildly gesticulates and screams, because the sister won't give him drug money, in a way that puts his sister in reasonable fear of serious bodily injury, and as a result, she gets distracted and falls off the mountain or has a heart attack that causes her to die. Or death could result from cyber-stalking under subsection A when the addicted brother sends his sister a barrage of texts demanding money for drugs and then further shows up on her walk home and starts screaming and gesticulating because she refuses to give him the money. Again, even though the addicted brother has no intent of threatening or harming his sister, he wildly gesticulates and screams at her in a way that, when combined with the barrage of aggressive texts desperately seeking drug money, puts his sister in reasonable fear of injury, and in the process, she gets distracted and steps into traffic and a fatal accident occurs. In all these scenarios, a death has resulted from the threat of self-harm or an unintentional or unknowing threat for force against another, yet, the Section 924, c. crime of violence definition has not been satisfied. It makes sense that Congress wanted to criminalize all these one-seater 2026 WL 145,348 at star 3 also conflicts with Supreme Court precedent because it relies on the realistic probability test that Taylor v. United States 596 U.S. 845, 858, 2022, eviscerated as applied to federal offenses, scenarios under the stalking and cyber-stalking statutes to broadly protect the stalking victim. Thus, this court must dismiss counts 3 and 4 of the indictment. Thank you for your consideration of this letter. Respectfully submitted, Karen Friedman Anafilo Mark Anafilo Jacob Kaplan Anafilo Intrator LLP Avraham C. Moskowitz Elon Schulman Christopher Neff Moskowitz Colson Ginsburg and Schulman Paresh Patel Special Counsel.
And basically in this document they basically break down and disprove every single little thing the prosecution talked about in their letter on January 3rd, 2026, saying, yeah, no, this doesn't make sense for these things to happen. That's what is discussed in this letter. Basically in this document, like we already know, the prosecution want to use the stalking charges to put charges 3 and 4 against Luigi Mangione and also the death penalty against him. And basically, like we saw before in the past, again, I talked about this quite a bit in one of my past videos, basically the stalking charges that they're putting on Luigi Mangione do not fall underneath that category for basically injuring someone, killing someone, or anything like that with those stalking charges like they're claiming. And they bring up here basically and explaining why it does not fall underneath that category whatsoever. And basically the reason why they should get rid of the charges 3 and 4 of the indictment against Luigi Mangione just because of those stalking charges they have against Luigi Mangione, and what they are using those stalking charges and putting on Luigi Mangione do not fit in that category for those charges to be put on Luigi Mangione because they are just stalking charges. Hi, it's voiceover me. I realized when I'm editing this video I didn't really make that sound really clear. I kind of sounded like I was saying the stalking charges have been dropped. I meant the charges 3 and 4 put on Luigi Mangione have been dropped instead of the stalking charges, so I thought I should put that here to clear that up, so I don't want to make any confusion here. Again, we will get to that later on in the video. That will be in probably like a couple of minutes. Again, like we already know, those charges have been taken off Luigi Mangione. We will get to that later on in the video. 27th of January 2026, the letter that was submitted that I just showed you has been approved. The 28th of January 2026. Hi, it's voiceover me. So I'm so sorry, I 110% forgot to talk about this document when I was filming. I think there was just so much I just forgot this one little document. But this document I'm about to show you is basically the document from the prosecutors, basically asking Judge Carro to set the court date before the court date that was set by Judge Garnett, and I'm going to put it up on screen for you guys. Again, I'm so sorry I forgot this entire document. It is very important.
January 28th. 2026 Honorable Gregory Carro, Justice of the Supreme Court of the State of New York, Criminal Term, Part 32 100 Center Street, New York, New York 10013 Re. People v. Luigi Mangione Indictment No. IND 75657-24. We are writing to request that the court set a trial date of July 1, 2026, in the above referenced matter. This case has been pending before this court since December 23, 2024, the day this defendant was arraigned on New York County Indictment No. 75657-24, charging him with murder in the first degree and related charges. Since that date, there has been extensive pre-trial litigation, including a 9-day-long suppression hearing and protracted motion practice before that. The people reiterate our readiness to proceed to trial in this matter. We filed certificates of compliance and readiness on 3 prior occasions. The statutory period for the defendant to contest our compliance has long passed. The only outstanding issues before this court are 1. A ruling on the defendant's suppression motions, and 2. Defense compliance with our reciprocal discovery demands. Both issues can be resolved well before July 1, 2026. This court will rule on the defendant's suppression motions on May 18, 2026. Moreover, the people repeatedly have demanded defense compliance. Yet, the people have not received any discovery, despite a series of statutory and court-ordered deadlines. By granting the people's parallel application, this court can ensure this case is ready for trial on or before July 1. As this court is aware, U.S. District Court Judge Margaret Garnett has scheduled jury selection in defendant's federal case for September 8, 2026, with the start of testimony to tentatively begin either on October 13, 2026, or January 11, 2027, depending on the court's ruling on the death penalty eligibility of the case, which is expected on January 30, 2020. There are significant state interests that are implicated by defendant's crime, its investigation, and its prosecution. These state interests would be unfairly prejudiced by an unnecessary delay of this important matter until after defendant's federal trial. On December 4, 2024, Brian Thompson, a 50-year-old father of two, was brutally executed by being shot in the back as he was walking into the Hilton Hotel to attend a conference. This heinous crime happened in Midtown Manhattan, one of the busiest commercial areas in this county, and spread fear and shock throughout Manhattan. New York State unquestionably has a deep interest in upholding the fundamental right to life, maintaining public order, and delivering justice for a murder committed in its jurisdiction. Indeed, almost all murders are prosecuted in this state by local prosecutors. For this reason, local law enforcement, the NYPD and the New York County District Attorney's Office led the investigation into identifying and apprehending Mr. Thompson's killer. Scores of NYPD detectives worked around the clock to find Mr. Thompson's killer. Specialized NYPD units actively participated in the investigation, including ballistics analysis, latent print analysis, and the crime scene unit. The District Attorney's Office drafted countless court processes to acquire necessary evidence, each item collected on behalf of a New York County grand jury and often authorized by a New York State judge. As a result of these efforts, on December 9, 2024, the Altoona Police Department arrested the defendant, based on photos disseminated by NYPD from surveillance footage local law enforcement had collected. A New York State judge issued an arrest warrant that day, which provided legal authority for the state of Pennsylvania to hold the defendant on our behalf. A New York County grand jury indicted defendant on December 17, 2024, just 13 days after the assassination. A total of 25 witnesses testified before the New York County grand jury. 6 of them came in from Altoona to testify. The remaining 19 witnesses were members of the New York City Police Department, New York County District Attorney's Office, New York City Office of Chief Medical Examiner, and civilians. Of course, the investigation continued for months after defendant's apprehension. In addition to the witnesses called before the grand jury, the NYPD and the New York County District Attorney's Office have interviewed many other witnesses and reviewed copious electronic data extracted pursuant to search warrants. Substantial state resources have been dedicated to this case, and New York State has a significant interest in this case proceeding to trial without undue delay. Federal prosecutors became involved on December 18, 2024, 2 weeks after Mr. Thompson was murdered, when a federal writ was served on NYPD to produce defendant into federal custody. It is entirely natural then that the state case would proceed to trial prior to the federal case. Indeed, the law countenances it. See United States v. Warren, 610 F2D 680, 684-85, 9th C 1980. Normally the sovereign which first arrests an individual acquires priority of jurisdiction for purposes of trial, sentencing and incarceration, and the United States Attorney for the Southern District of New York has said that it expects the state case to proceed to trial first. See press release, Luigi Mangione charged, Department of Justice, SDNY December 19, 2024. Moreover, the reverse would unduly delay the state trial first, during the federal trial itself, and then, during the protracted litigation that would follow on the impact a federal verdict would have on the state charges. In sum, the state has an overriding interest in trying this defendant for the cold-blooded execution of Brian Thompson on December 4, 2024. It resulted in the tragic death of a guest to our city on our streets. Federal law supports our request that we proceed first, and our right to a speedy resolution of this case would be severely compromised should the federal trial proceed first. We therefore request that the court set a July 1st trial date. Sincerely, Joel O. Seidemann, Joel J. Seidemann, Assistant District Attorney, Senior Trial Counsel, CC, Karen Friedman Anafilo.
This is a statement from Karen Ockefellow about them deciding the court date for Luigi Mangione's case on June 1st, 2026. I'll pop up on screen for you guys.
Please note that this statement is in response to the Manhattan District Attorney's Office's written request for the 1st of July 2026 trial date. This is the first that the defense is hearing about this request. The federal government already has a firm trial date set in September. As a practical matter, Mr. Mangione's defense team will require the remainder of the year to prepare for that trial. We will respond to the court about this unrealistic request in the coming days.
29th of January 2026. This is a document from the prosecution organizing court dates. I'll pop it up on screen for you guys.
January 29th. 2026 via ECF Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, 10007 Re, United States v. Luigi Nicholas Mangione, 25 CR 176, MMG, Dear Judge Garnett, pursuant to the court's instruction of January 23, 2026 evidentiary hearing, the parties have conferred regarding the use of a jury questionnaire and the timing of its administration, including its effect on jury selection, which is scheduled to begin on September 8, 2026. The parties are in agreement that a jury questionnaire is necessary in this case regardless of whether it ultimately proceeds as a capital matter, given the extraordinary media attention and publicity surrounding this case. The parties therefore jointly propose the following schedule governing the submission, briefing, and administration of juror questionnaires: April 13, 2026, exchange of proposed questionnaires between the parties, May 4, 2026. Any objections to proposed questionnaires, May 18, 2026. Oppositions to objections, June 1, 2026. Replies, if any, June 15, 2026. In-person distribution and preparation of approved questionnaires to summoned jurors at courthouse. This proposed schedule will provide the parties with a meaningful period of time to review and assess the completed questionnaires submitted by individual members of the jury pool, to identify prospective jurors who should be excused for cause, and to prepare for the exercise of each side's peremptory challenges. The parties respectfully submit that this timeline will promote an orderly and efficient jury selection process in a case of this complexity and public profile. Respectfully submitted, Sean S. Buckley, Attorney for the United States Attorney acting under authority conferred by 28 U.S.C. Section 515 by S/Dominic A. Gentile, June Zhang, Alexandra S. Messiter, Thomas John Wright, Assistant United States Attorneys, 212-637-2567 per 2295/2544 per 2289 cc, Counsel of Record, via ECF.
And they are requesting for a questionnaire about this case just because of how viral this is, because basically if you're called for jury selection, you're meant to be biased, you're not meant to lean one way or the other, but especially how viral this case is, there's a lot of people that are one way or another in this case. The prosecution organizing for the court date here, 30th of January 2026. So Luigi Mangione appeared in court again on this day, and really big thing happened on this day. So basically the death penalty was taken off Luigi Mangione. That was 110% unfairly put on him in the first place. That is a massive win for Luigi Mangione and his legal team. I did talk about this before in the past. If I was more awake and not tired, I would sound more excited, but I am very, very excited about this. And also charges 3 and 4 were taken off Luigi Mangione as well on this day. Again, that is massive news for Luigi Mangione and his legal team. That is absolutely amazing. that has been taken off the table for Luigi Mangione. Like, I can't imagine just having that dangled over your head for a full year. I remember when it first came out, I heard I was actually going through a lot as well around that time as well. I had a little panic attack, not so out of fear, just more so out of like excitement. That sounds really weird, probably too much to let you guys know on the internet, but whatever. That's what I felt when I first heard the news. So anyway, easy news for Luigi Mangione and his legal team, and it must be a massive relief for Luigi Mangione and his legal team, and also Luigi Mangione's family, knowing that. Another thing that came out on this day is a lot more really big documents as well, that I will make it its own dedicated video that also came out on this day. One document that came out, I made its own dedicated video. It is the pre-hearing Memorandum of Law that came out on the 30th of January 2026. I made it its own dedicated video, and that was last week's video. If you guys haven't listened to that and you don't want to read it, and then the other two documents that came out, and then the other document that came out also by Karen Ocafillo, that will be its own dedicated video as well. And then the third document that came out on this day is from Mark Ocafillo, Karen Ocafillo's husband. I mentioned him a couple of times. He hasn't been part of this case the entire time in Luigi Mangione's legal team, but he did join. I don't know when, but like sometime last year he did. But there is another massive document from him, so two of those documents will be its own dedicated video. Yes, I know there are a lot more documents in the video I should have read first before the pre-trial Memorandum of Law document. I do apologize, I just forgot the one I saw earlier, but those two documents will be its own dedicated video. But they came out on this day, tackling the death penalty against Luigi Mangione. And we also got a statement from Karen Ocafillo in front of the courthouse about this decision made by Judge Garnett. Anyway, I'll pop it up on screen for you guys.
Good morning, good afternoon, everyone. Just wanted to thank the court for this incredible decision. I want to thank this amazing legal team that we have here. It's really wonderful, all of them. And thank all the people who come out and stand here in the cold, and the people who can't come here, all the supporters. We get your letters, we get your emails, and we really appreciate all the support. So thank you all. Stay warm.
Karen, what was Mr. Mangione's reaction when he learned the death penalty was off the table?
We're all very relieved.
What was the reaction last night to the attempted breaking Luigi out of prison?
Honestly, we have a big filing that we filed in state court last night, and we were anticipating today, so I don't know anything about that. I heard about it and understand that there was not even any mention of Mr. Mangione, so I don't know that it is even related, so I really don't know anything about that individual.
Karen, how much of a setback is it that the judge is going to allow the contents of the backpack at trial?
We're prepared and have been prepared to fight this case, and we look forward to fighting this case. So,
do you have any comment about the state trial happening at the same time or possibly earlier than the federal?
We're going to work that out with everybody, but we anticipate fighting these charges. So thank you. Thanks, everyone.
It's not for you to hang on with people to walk through.
You know, double jeopardy is a big thing here, right? Mr. Mangione is being charged in 3 different cases for one incident. So we're going to continue to fight for that as well. But thanks, everyone. Thanks for being here.
Bye, everybody.
And now I am going to be going over my little notes of that full document of the pre-hearing Memorandum of Law. I am just going to be going over my little notes and breakdown of that full document, so it's like a little bit more understandable. And basically in this document, it's very much them going in detail and in depth of what was discussed and talked about in the December suppression hearing. Honestly, I do recommend to go just read this document if you don't want to watch my Lord of the Rings length-long videos. It's all nicely compact in this document for you guys to read of every single itty-bitty detail that came out that is incredibly important. A lot that is discussed in this document that was very much just came out in the December suppression hearings. So if you think I'm repeating myself from the live tweets December suppression hearing videos I made, it's very much just what this entire document is. It's just a shorter, compressed version of all the very important details that came out in this December suppression hearing that everyone needs to know about. So I recommend to just read this document than watching my videos, because just time, honestly. Unless you want to, they're there. It came out in the document basically adding another layer of the incompetence of the Altoona police officers. So Officer Fox accused Luigi Mangione for giving them another fake name because Luigi Mangione did not appear in the system, and then it came out Luigi Mangione asked did they spell his name correctly, because full name is incredibly Italian, like it's literally Luigi Nicholas Mangione, like how more Italian can you get than that? So, and also, like we already know, the Altoona officers are pretty ignorant. Like we already know, they don't know the difference between foreign currency and the U.S. dollar, but it kind of adds another layer of them being incompetent, and basically Luigi Mangione spelled his name so they can get it in the actual system, but just misspelled his name, and that's why it did not appear in the system. Basically argue about the suppression of Luigi Mangione's backpack, because literally Luigi Mangione was not in control of his backpack. There were so many officers between Luigi Mangione, him, and his backpack. He had no control over it whatsoever, and like every single officer, and also now the prosecutors, they are also saying no, it was an inventory search, it was totally fine for them to do. We'll say in quotation marks here. And in reality, no, it was not okay for them to do the inventory search that they are all claiming they did on Luigi Mangione's backpack at the McDonald's, at the police station, in that hallway where there were no CCTV camera for Featherstone's office, and then in that call room, and then into a different entire room altogether, when they've done that so many different times when they were not meant to do that whatsoever. So they argue basically saying, yeah, no, they weren't doing inventory searches when they did that whatsoever, and basically suppress everything they allegedly found in Luigi Mangione's backpack because of that reason, and they go into a lot more detail and stuff in the document about that. And they also argue in the document this is a New York case because the crime happened in New York of the shooting of Brian Thompson, and the trial is happening in New York, but they are using Pennsylvania rules in a New York case where that literally doesn't make sense. They are two entirely different states. And I don't live in the United States, and I know that. So it doesn't really make sense for them to use Pennsylvania law when it is a New York case, if that makes sense here. So I realize I say if that makes sense quite a bit. I don't know why. Like, I think it's a key thing from my childhood when I explained something to a teacher and then they looked at me and they said, I don't get it, it doesn't make sense. And I say that if it makes sense, to like maybe if it doesn't, I'll rephrase it to make it make sense. And now I feel like everything I say or describe or explain doesn't make sense to people, and that's why I say it. Anyway, things that stick in your brain forever. So yeah, I do apologize if I say that, if that makes sense a lot, because I'm unsure when I'm explaining things if it does make sense. Like, I think so, to me. I don't know if other people. Basically, like what all the prosecution and Pennsylvania officers keep saying they were doing a inventory search in Luigi Mangione's backpack. Even in Pennsylvania law and also in New York law, Luigi Mangione's backpack was way too far from him, or he wasn't even in the room for when they were doing that so-called inventory search they all claiming they were doing surrounding Luigi Mangione's backpack, and everything should be suppressed because of that reason, because literally it wasn't an inventory search what they were doing. We already know, it's bluntly obvious, unless you're bluntly ignorant and refuse to see what's in front of you. And they also want every single statement from Luigi Mangione suppressed before his Miranda rights were read to him, because literally they kept asking him questions, they kept asking Luigi Mangione questions and also interrogating him before his Miranda rights were even read to him at that McDonald's, and they need to suppress every single statement Luigi Mangione made because of those reasons. Again, we've discussed this many times before in the past, but it's very important if they need to suppress these, because literally what they're doing is incredibly sketchy and dodgy, like we already know. Invalidating Luigi Mangione's 5th and 4th rights. Like we already know, they don't care about Luigi Mangione's rights in this entire case. We've seen it so many times, you know, like the massive HIPAA violation that the judge gave him a slap on the wrist for. And they also bring up as well, basically, several officers basically admitted no, they weren't doing an inventory search whatsoever. Same thing with the bomb excuse. It very much came out, basically, it was a fucking lie, and they were very much joking around and all that when they were going through Luigi Mangione's backpack. Again, the entire thing they weren't taking seriously whatsoever. It's insane. And basically they also bring up as well, they broke Supreme and also Pennsylvania law for them basically going through Luigi Mangione's backpack without a search warrant, and then also reading his alleged writing and also the alleged notes that they found in Luigi Mangione's backpack. They basically broke those two laws. So I do apologize about my little notes, just a little bit all over the place. I write my notes when I am reading the document, so like say after I read one page, I write my little notes from that page, if that makes sense. So sorry if it's a little bit all over the place. You guys don't mind too much. I do apologize though. They also bring up as well Officer Waza and also Officer Fox when they were illegally searching his backpack at the McDonald's. Basically, another officer told them, hey, you guys need to get a search warrant, but like we already know, that was so in the live tweets, and also it's brought up here as well. It's in also body cam footage. They were told they need to go get a search warrant to go through Luigi Mangione's backpack, but like we already know, they just bluntly ignored that person, that officer, and just kept searching for Luigi Mangione's backpack anyway. It also comes out in body cam footage as well, that's also brought up in this document. Officer Fox and Officer Waza did not do a thorough search of the backpack, but like we already know, they did a much thorough search at that McDonald's than they were letting on, like we already know. They also bring up in the document basically saying Officer Fox also said they can do a further search of Luigi Mangione's backpack at the police station, but like we already know, they already done a thorough search of Luigi Mangione's backpack at the McDonald's than what they're letting on, like we already know. And basically, again, Officer Waza and Officer Fox were told they need a search warrant, but they bluntly ignored that officer and just kept going for Luigi Mangione's backpack anyway, and basically breaking federal and also Pennsylvania law. Doing that, like we already know, several officers went through Luigi Mangione's backpack without a search warrant that they need 100%, but they did not do that whatsoever. These officers and prosecutions love breaking laws with no consequences. They need to be consequences for that shit. Then what are rules for if no one follows them or consequences don't happen? They also bring up the amount of times Luigi Mangione's backpack was searched without a search warrant, like we know, so many more times than we knew from the beginning as well in the live tweets. Again, we went over that in the live tweets. Basically, them using the bomb excuse to go through Luigi Mangione's backpack was just a excuse so they could look for evidence in Luigi Mangione's backpack at the McDonald's. But like we already know, they found that gun magazine and made their decision right then and there. But like we already know, they kind of did that anyway once they stepped foot into that McDonald's, even before they saw Luigi's face. They also bring up the amount of times Luigi Mangione's backpack was searched at the police station itself, and also when Officer Waza searched through Luigi Mangione's backpack in that hallway without any CCTV camera footage to go through his backpack, and that entire situation was not recorded whatsoever. Like we already know, she does not turn her body camera on and off at will. She just does it whenever she feels like it, when it's necessary. Any CCTV camera footage, that entire situation is not recorded, including that situation when she pulled over the side of the road with Officer Fox, and Officer Fox handed her a brown paper bag with some of Luigi's things in it. It's incredible. It's very sketchy, so sketchy. If I wasn't losing my voice, because I've been doing this for all goddamn day, it would be louder. But they bring that up as well, and basically every single officer basically was breaking Luigi Mangione's rights in New York and also in Pennsylvania when Luigi Mangione was first arrested, because again, what they were claiming they were doing is literally breaking Luigi Mangione's rights in those two states for literally going through his backpack without a search warrant. It does fall underneath Pennsylvania law and also New York law. want to suppress Luigi Mangione's statements, he said, to the Altoona police officers because they still even questioned and interrogated Luigi Mangione at the McDonald's even when he was told his Miranda rights and he chose to be silent. That is his right to do so, but they kept doing that anyway. And they also bring up the bias Officer Detler had towards Luigi Mangione before he even got to that McDonald's, because literally he thought he caught the CEO shooter. He wanted to be the hero. Same thing with Officer I. Again, they all went in with an unfair bias towards Luigi Mangione, and no matter what he said, they would have pinned something against him no matter what, and it's bluntly obvious here. Officer Detler and Officer Fox, basically where they got their information of what the CEO shooter looks like, they brought up basically they only got their information from Fox News instead of from, like, official sources higher up. And like we already know, another officer, he called a 911 operator. The only guy was trying to do his best to call someone in New York about this entire thing, compared to basically everyone else who only watched Fox News and got their information from there. Basically bring up why did Officer Detler 100% knew they caught the CEO shooter once Luigi Mangione pulled his face mask down at the McDonald's. Again, one of the officers came in, and when they saw Luigi Mangione wearing his face mask, like the only one in Pennsylvania wearing it, they go, yes, that's the guy, instead of actually asking the McDonald's worker who would it be. And when the officers were asking Luigi Mangione questions, before Luigi Mangione could even answer the officers' questions, they told Luigi Mangione to stand up and do a pat down, and basically one of the officers directed one of Luigi Mangione's arms above his head longer than 15 seconds when they were doing that pat down. So bring up when the Pennsylvania officers were lying to Luigi Mangione, basically saying, oh, this will be all done and dusted when we verify your ID. And same thing about when another officer lied to Luigi Mangione. They went to McDonald's 6 times for someone loitering at McDonald's. In reality, that's a lie. You can stay at McDonald's as long as you want, no one cares. They bring up as well when that officer who called the 911 operator in New York to actually try to call someone in New York about this entire thing, trying to do the right thing, instead of actually, taking the extra steps of actually contacting someone who is in the investigation of the shooting of Brian Thompson. They only called a 911 operator, but they didn't want to do the extra steps to actually call someone in New York who is working in that department, instead of just a 911 operator who, just answers people's calls about if someone's dying or not. They also bring up the amount of times when Luigi Mangione was patted down. Like we already know, they patted down Luigi Mangione multiple times at that McDonald's, and like we already know, with the first 2 pat downs, they didn't really find anything. Not even that jar of fucking peanut butter that lives rent-free in my brain. Another layer of them incompetence. Like, how do you miss that? And they also bring up when the officer asked Luigi Mangione, is that his laptop and also is that his backpack? And when Luigi Mangione said yes, that is his backpack and his laptop, the officer moved it away from Luigi Mangione, making sure it is out of his reach. They bring that up as well in this document. They also bring up when Officer U.A.S.'s body camera off. Like we already know, she did not have it on majority of this time. And they also bring up basically her body cam wasn't even on when she was in that hallway without any CCTV camera footage in it whatsoever. And again, that entire situation was not recorded. They also bring up as well in the document as well when Officer Fox and Officer U.A.S.'s interaction when they both pulled over to the side of the road, that was not recorded by either officer whatsoever as well. Again, bringing up the amount of times Officer U.A.S.'s camera was not turned on whatsoever. Again, she just loves turning it on and off when it conveniences her. Lady, you're meant to leave it on at all times. They bring up as well, because they went in there and they were going to put the fake ID charges against Luigi Mangione because he handed over the Mark Rosario ID, and basically Luigi Mangione was asked why did he have a fake ID, and then Luigi Mangione said that was the ID he had in his wallet, and basically because they were claiming they're gonna arrest Luigi Mangione for fake ID charges, but Luigi Mangione already admitted he had a fake ID and it told them his real name. They should not arrest him for that, because literally not arrest Luigi Mangione for the fake ID charges when he already admitted it and told them his real identity. They also bring up in the document, by the way, the pocket knife Luigi Mangione told officers he had in his pocket was not illegal to have. It was just a little standard pocket knife that's illegal to have, compared to those big scary pocket knives in America that you can also carry around that is illegal, compared to the pocket knife Luigi Mangione just had. They also bring up when that officer who walked up to Luigi and took that photo of Luigi at that McDonald's, making it his unofficial first mugshot, and the reason why he did that, he was sending it to the NYPD. Again, there's so many officers, as I kept saying, they weren't working for the NYPD, but then everything they'd be doing was for the NYPD before they even got involved. It's so nice of them to do that, but again, it's their actions say otherwise what they were actually doing compared to what they're saying. Once Luigi Mangione was in the police car, he asked for the officers' names and then also said sorry for wasting their time, and that honestly melts my heart every time I hear that. It's so sad. It's so sad he said that. Like, you don't need to apologize. They also bring up basically Luigi Mangione is very calm, very compliant through the entire situation when he was being arrested at the McDonald's, and like we already know, one of the officers lied and said Luigi Mangione was very nervous, very shaky, and in reality that wasn't true whatsoever. It's very common for officers to lie about that shit. And they also bring up basically the officers were not taking this situation very seriously, like we already know, when they were joking around and cracking jokes about the bomb. They were literally, Luigi didn't say anything because that's his right to do so, because Officer Fox wanted him to say something. Do you guys remember? I do. They also bring up in the document as well, that was also heard in the body cam footage as well, Officer Weiser asked, oh, should I put this in bags? Basically doing the work for the NYPD. So helpful of them to do so. Again, they keep saying they're not doing anything for the NYPD, but their actions say on. And like we already know, they did so much for the NYPD, but then, the NYPD asked them not to do so. It's also brought up as well when Officer Featherstone got things. Basically, some things were in envelopes, some things weren't in envelopes and just put in Luigi Mangione's backpack, and the things that were in the envelopes weren't labeled or anything like that, like we already know. Detective Leonardi said once he heard the news from one of the officers from Pennsylvania about they may have the CEO shooter in custody again, other uncertainty of them saying maybe, Detective Leonardi said, hey, do not do any further investigation in this. They want him and his team to question and ask Luigi Mangione, but like we already know, people in Pennsylvania bluntly ignored that and just did it anyway. Like we already know, they did things for New York and they never asked them to. Also comes out one of the officers that was actually doing the inventory search of Luigi Mangione's backpack. Like we already know, it was 3 officers who read through Luigi Mangione writings and were claiming they were doing a inventory search. One of the officers admitted, saying, yeah, he only did it just out of curiosity, no other reason, and that's why he did it. They brought that up in the document. And also the other 2 officers that also read through Luigi Mangione's alleged writing, that was also included. Officer Waza, like, it comes out she didn't read it, she just did a light skim of it when she came across the alleged journal that was found in Luigi Mangione's backpack. Like, when you read a book and see if it's any good or anything like that, you do a light skim. That's what she did, compared to the other 2 officers that actually read through Luigi Mangione's journal. And like we already know, when the officers were taking photos of Luigi Mangione's alleged writings, they only took photos of certain pages instead of, every other page. Things could be taken out of context. Detective Leonardi basically recorded Luigi Mangione without his consent. Like we already know, Pennsylvania is a 2-party state, basically meaning if someone is being recorded and interviewed by the police, they are both meant to know they are being recorded. But Detective Leonardi did not tell Luigi Mangione whatsoever he was being recorded whatsoever, and basically his entire statement was shut down. So Detective Leonardi wasn't be able to be questioned by Garnet Arcafilou or Mark Arcafilou. Again, very annoying. I would have loved to hear what he had to say, but it very much does come out. All these people were just rushing because they all wanted to be the ones to catch the CEO shooter after that 1 week manhunt, and they were all so excited for it. They were rushing things, they were forgetting things instead of, actually doing their jobs correctly. Like, it's clearly obvious the goddamn ignorance going on and how much they were all rushing things just because they all wanted to be the ones to catch the CEO shooter instead of actually, looking into things. It's absolutely insane and absolutely infuriating. Comes out as well in this, the prosecution wanted to use Luigi Mangione's statements in that illegal recording, but they are not allowed to use that whatsoever because, it was a crime. And they also bring up, basically, if you remember, in Pennsylvania when Luigi Mangione was being held before he was sent to New York, the officer that was looking over him and claimed Luigi Mangione said a bunch of statements to him that were going to incriminate him, but he did not write any of this stuff down whatsoever. Like, it's a little bit stupid. Oh wow, incredibly important stuff, this could help us. They did not write that whatsoever down, but they just assume we'll just take their word for it, when in reality, if he actually said that kind of stuff, that would be incredibly important to write down, but he did not write any of that down whatsoever. Same thing what Officer Fox said as well. Again, none of that stuff they said was true. Bring up why it's incredibly suspicious he does not remember any other conversation he had with Luigi Mangione, just those very incriminating things Luigi apparently said to him. Well, multiple officers said they've done this multiple times with other witnesses in the past, going through basically their items without getting a search warrant, and it's absolutely fucking infuriating. This comes out. They've done this multiple times with other people, and who goddamn knows what happened to those people because they literally looked for their items without a search warrant. Like, this is the Altoona police force. Like, what the fuck? This is fucking infuriating. They also bring up, like, why did it take Officer Waza 2 more minutes to get to the police station compared to every other officer? Like, there's actual footage of them taking Luigi Mangione from that McDonald's all the way to the police station. They also know they had to stop at a red light when they were taking Luigi Mangione to the police station. So why did it take Officer Waza 2 more minutes to actually arrive back to that police station after she got that brown paper bag from Officer Fox? Again, they do go quite in detail about how suspicious their entire interaction was, because it was. Like, it so is. It's bluntly obvious, and if you can't see it, why are you on this channel? Yeah, basically they go in quite a bit of detail, basically the incredibly suspicious acts from Officer Waza, Officer Fox, and every other officer in this entire case. It very much is a condensed version of what the December suppression hearing is, basically what everything happened in the 3 weeks, in the small little details of things, basically compact into like one document. I recommend to go read this document compared to my videos, even if I should say go watch this video's promotion. I'm not good at that, but I want to watch and sit through those videos. They're incredibly long. I do recommend to just go read this document. It very much just covers all these small little details of things that are incredibly important of what every single officer said in this case, in Luigi Mangione's case when he was arrested. Again, it's absolutely insane. So many things came out in these December suppression hearing that's incredibly important in Luigi Mangione's case of what the hell was going on, how goddamn incompetent these officers are, and their bias towards Luigi Mangione before they even got to that McDonald's to arrest him. Again, I do apologize, this little bit isn't as thorough as I normally do, because literally I'm like reading it going, I already said this. I said this for 3 weeks in a really long video, so I do apologize, it's not as in-depth as I did before in my other videos. Again, I've already talked about this multiple times, many times, but basically what was discussed in this document was very much in those live tweets that happened in December, if that makes sense. So again, I do recommend to go read this document, or if you don't want to read it because it's very long, go listen to my audio version of the document if you don't want to read it or you don't have time, etc. So I don't know why I can understand this, but explain it to you guys. I don't even study law. I went to film school. How do I understand this? I just do. Okay, so that is the end of the updates in Luigi Mangione's case from all the way from December last year all the way up to January in Luigi Mangione's case. And now we are going to be moving on to my little notes and things I want to talk about that aren't really that important, but I still want to talk about it anyway. It won't be too long this time. I need to have dinner soon. Okay, so that is the end of my little notes and breakdown of the hearing memorandum of law in Luigi Mangione's case. And now we're going to be moving on to things that aren't really relevant to Luigi Mangione's case, but I want to bring up anyway, or things that were important but not really necessary for the main part of the video, like, you know, legal documents and stuff, but I still think they're important to talk about anyway. Don't worry, it's not too many, so I won't hold you up for long, and then I'll let you guys go. Actually, this I noticed the other day, actually, when I was on Reddit, on the Brian Thompson murder sub. I came across this article basically saying the stalker who was harassing Brian Thompson's wife has been officially sent to prison for 5 years, and I think that person should be looked into more than Luigi Mangione, if that makes sense, because that has more motive behind things than what they are claiming Luigi Mangione did. I thought that was incredibly interesting. I'll put it on this week's episode on the website if you want to check it out. I thought that was incredibly interesting when I came across that. But again, Reddit, do take it with a lot of skepticism. It's not a official source or anything like that. Basically, here are some articles people have sent me that I think that are quite interesting, and I do recommend to go read. One of them's from Reddit and one of them's from somewhere else, but I do recommend to go read them. They're going to be on the law website if you guys want to go check them out, and I find them like very interesting, but they weren't really like relevant to talk about in the main part of the video, but I do find them very, very much important as well. Basically, I'm noticing as well quite a bit the restriction talking about Luigi Mangione is getting more and more strict now. I'm noticing on different social media platforms, like you already know, my channel got taken down. I blame shorts, honestly. I notice that quite a bit actually. I get more in trouble if I post shorts than my longer videos I find quite interesting on YouTube, but I'm noticing it quite a bit on TikTok as well. So now you can't say basically gun, kind of normal, but now you can't even say Brian Thompson, Luigi Mangione, or even officer or police officer on TikTok, and probably a bunch of other words too. I find incredibly interesting. I just want to note that here. But it's kind of alarming, the restriction surrounding Luigi Mangione's name is getting more and more strict. On the 16th of January 2025, TikTok basically gave my account 2 strikes, and I literally did nothing wrong. I do not know why, and it's kind of alarming. I think I have like 1 more strike while my account gets taken down. I think this time I was literally just repost something and I got those 2 alarming strikes, but I'd like to note this happens every single time. Basically, I've been seeing this a lot lately, and I find it incredibly alarming. There's been a lot of people that hate Luigi Mangione, that are targeting Luigi Mangione supporters, that are just basically doing what I'm doing, just sharing all the accurate and correct information, and those people that hate Luigi Mangione are going after those people and saying the most horrible and heinous things towards them. Like, you should never say these things towards another human being. It's absolutely fucking disgusting, and it's sad it keeps happening. Like, I've heard it multiple times to different people that I also follow, and people keep saying these mean and horrible things towards them that you should never say towards anyone. Like, literally all they're doing is just sharing legal documents like what I'm doing. And also I've been noticing this as well quite a bit as well, where there's other people in the Luigi Mangione supporter realm, internetness, where they target other Luigi Mangione supporters. It's really weird and crazy, like being really mean to them, targeting them, very much mean girl, bitchy energy. Men or women, who knows, but they also like kind of act like bitchy teenage girls. I've been noticing that too, and they kind of target other Luigi supporters. Seeing this a lot more. We will go over what I said earlier in the video in a minute, but I've seen it a lot more. Again, I'm hearing it from a lot more other accounts that talk about Luigi Mangione's documents and mean horrible things that have been said to them by Luigi Mangione supporters, or even just like totally strangers that hate Luigi Mangione whatsoever. And I think it's absolutely insane. People that support Luigi Mangione are also targeting Luigi Mangione supporters. Like, why are you acting like a mean bitchy girl? Like, I generally don't understand why this is slowly turning into a divide thing. Like, I've noticed it, but it's happening more and more. I've noticed over the last couple of months where it's like there's been a divide, and I seriously don't get it. This is happening. Like, I feel like we should be more united, you know, instead of like targeting other people, if that makes sense. We're all here for the same reason. We're wanting to support one man whose trial is absolutely insane because politics decide to get their hands involved this entire reason. Why do they feel like it's okay to target other people? Because, you know, for some stupid reason, because they have like a pick-me energy or whatever. I generally don't get it or understand. Like, why? I generally don't get it. Why do women feel like, or men feel like it's okay to target other people when they're both in the same thing? They both support the same person. I generally don't get it. But I've just been noticing that a lot more, and I find it absolutely sad and tragic, honestly, hearing those stories from those people where this keeps happening to them just because they are like more bigger and more popular. This kind of stuff keeps happening to them. Again, I've heard this multiple times from different people's accounts and experiences with this, and luckily it hasn't happened to me. One, I think it's because I'm not that big enough in the Luigi Mangione supporter realm for people to know me, so the only thing I get was like on my shorts of them, a person calling me a slob because they don't like my top I'm wearing that day, or, you know, on TikTok, someone asked me how much for me was for a night, but in Spanish. TikTok, why did you not take that comment down when I requested it? It doesn't matter if it's not in English. That's like the only shit I get. But if I was probably bigger or had more followers, I think that kind of stuff would have happened to me, especially because I show my face when I do this kind of stuff. I don't think it doesn't really happen to me because I'm not that big in the Luigi Mangione space supporter realm, if that makes sense, compared to the other people where I see it keep happening to them just because they have a lot more followers and all that. But it doesn't really happen to me because, you know, I'm not that big. People don't really know who I am, except for like a handful of people. Hi, you're all great, you're all nice. But I just want to know this is happening, and it's very alarming. Like, the divide and the horribleness is getting bigger towards those people, and it's absolutely upsetting to see it's happening. So, if you see anyone who is being an absolute asshole to someone in the Luigi Mangione's supporting realm, or just in general, report them, okay? There's no need for that, okay? Don't target someone because they just want to spread correct information about things. Don't target them because, you're annoyed with them. It's dumb, okay? Grow the fuck up. We're all adults here. Why are you acting like you're a jealous 15-year-old girl? It makes no goddamn sense. It's bullshit. Sadly, there's a lot of people out there that refuse to grow up whatsoever. Okay, now we're going to be moving on to the probably bit that I mentioned earlier on in the video. Okay, so I did bring this up earlier on in the video, but I talked about it briefly. I also brought it up in like one of my videos going over the December stuff just because it was quite big. So I did get this from Instagram. It could be bullshit, it could be lie, but I have heard these instances happen to other people that were able to go to the hearings in Luigi Mangione's case in multiple different times, and hearing those occasions happen from other people, it does kind of confirm a little bit this maybe kind of stuff could be true. but I just want to bring this up here anyway, just because it was quite a big thing in the Luigi Mangione supporter fandomness. So basically, and also I will not say this person's name. One, I don't remember, and two, I don't want to give this person more internet fame than they already got. But basically, what happened, a person who is really big in the Luigi Mangione supporting realmness, you've seen her a couple of times in the Luigi Mangione live streams. When you see people walk up and down the hallway, you can probably go find her if you're good at stalking people online, or even just, click 2 buttons. But basically, this person basically was a very mean and horrible person. Basically this, and I brought this up earlier in the video, this same person basically became friends with someone in the courthouse and was able to get access to some documents and also CCTV camera footage in Luigi Mangione's case. I do not know how the hell they managed to do that, but they managed to get access to that, download it, and then release it to the public. And I think it's a very disgusting and scummy thing to do for someone to claim they are supporting Luigi Mangione and decide to release that kind of stuff for everyone to see. The internet is forever. These little videos I make are gonna be on here forever, until even when I'm dead. Maybe my great-great-grandkids will see me at the age of 25 doing this weird shit. It's like, why did you do this? You're a weirdo. Anyway, we're moving off topic. A very disgusting thing, I think, for someone for claiming they want to support and care about Luigi Mangione, for someone to actually release this kind of shit. For what? Internet attention? Luigi Mangione's attention? Legal force attention? Why? It is very much giving off pick-me-girl energy. Look at me, look what I've done for you, allegedly. But that did come out, and that was a fucking massive thing. Basically, they monitored the line system for Luigi Mangione's hearings, so basically you had to know this person and basically what they did, they had a line ticket system, by the way, was not there whatsoever, so they could basically give someone a number, and those people in the line that had that number could go into the courtroom to support Luigi Mangione, and the only way you could get that number was if you were friends with that person on Discord. Now, they do not work for the courthouse whatsoever. They are just a random person on the internet who supports Luigi Mangione, who is able to go there and spend quite a bit of money to go there in person. That shit's not cheap, and literally, if you do not know that person whatsoever, you wouldn't have gotten that ticket. And I've heard that actually multiple times from other people that were wanting to go to support Luigi Mangione at one of his hearings, and they saw that ticket thing. And again, that was not meant to exist whatsoever. It does not exist. It was a very disgusting and scummy thing for them to do, to basically pick and choose their friends to go to support Luigi Mangione and be in the courtroom itself, instead of actually letting people that, say, could afford to take one day off to go to support Luigi Mangione in court, or was able to actually, save up the money to go, or even go to the United States and go do it in person, etc. Instead of, the ticket thing, because, they're besties on Discord. It's a very disgusting it's very much mean girl energy of them to do that. That was also brought up in these Discord screenshots, and some people were targeted because this person did not like them, and then they got their little friends to target that person, smear campaign them, and this has happened to multiple other people just because this person did not like another Luigi Mangione supporter. So they got them and their little friends to target them online. Again, very much mean girl behavior going on here. And the reason why not many people came out and talked about this is because they were very powerful in the Luigi Mangione community, and a lot of people were very scared of them and did not want to come out and say anything. And that's a sad fact with a lot of people that are bullies and horrible people. A lot of people are too scared to come out and say things because sadly victim blaming is very much a thing. It's disgusting, it still happens to this day. But a lot of people were very, very scared to come out and say anything about this. And honestly, I want to say a massive thank you to the person who was brave enough to take screenshots of the Discord of all this that was revealed to the public and post online to everyone to see. So thank you for being very, very brave to post this for everyone to see, and thank you for the people who posted this on Instagram so I can see it and talk about this, because holy shit, this was a big thing in Luigi Mangione's case. And I don't really talk about gossip or anything like that. It's not what I do. It's not very much like a person I do. I really don't give a shit about that kind of stuff. It's very much who I am. It's very much not what this channel is. I don't give a shit about the drama in the Luigi Mangione. The only time I will step in and talk about it, because literally what this person did is going to affect Luigi Mangione's case in a big way, and I'll put them up on screen for you guys so you guys can go pause and read the screenshots if you want to, or you guys can go check it out. I did repost them on my Instagram if you want to go read them there, or they'll be up on the website there if you want to go read them. I just wanted to bring this up here because I think it was very, very important, because literally a Luigi Mangione supporter is literally going to affect Luigi Mangione's case in a big way just because they just wanted a little bit of attention. Why? It's absolutely fucking infuriating. So yeah, I just want to add this here. Also, I feel like in this entire case, ever since the December suppression hearing, literally everything has been scrambled, I feel like, in Luigi Mangione's case. From prosecutors, from Luigi Mangione's legal team, everything's just blending in and turning into a massive knot, I think, anyway. It's absolutely insane, I think, anyway. From the goddamn, incompetence from the Altoona police, the politics wanting to get involved into Luigi Mangione's case, so much more coming out from the Altoona police, and when Luigi Mangione was arrested, bias towards Luigi Mangione, and basically the incompetence going on, and then just going, yes, we got the right guy before they even got to that McDonald's. And we already know, all these officers went into this McDonald's with an unfair bias towards Luigi Mangione because they all wanted to be the ones to be part of this massive investigation of the CEO shooter and being the ones who catch that guy, compared to actually doing their jobs correctly. And all the odds were stacked against Luigi Mangione ever since that 911 call was made. It's absolutely insane how much incompetence came out in this entire case surrounding Luigi Mangione's arrest. It's absolutely insane, and everything's just getting scrambled. Oh my god, that's what I think anyway, ever since the December suppression happened. Again, so much more crazy information came out in those December suppression hearings. Even more things are coming out now, even as we're making this video, in Luigi Mangione's case, that are just making things more entangled and more crazy. In Luigi Mangione's case, where the prosecution and also the Pennsylvania police force do not want Luigi Mangione to have a fair trial whatsoever. And it's absolutely insane how much it keeps going on and on and on ever since literally 2024 in this moment in time. That was such a long time ago, and now it's so scrambled right now. I think that's probably the best way to describe this entire case right now. And Luigi Mangione deserves a fair trial like everyone else, and they're trying so hard to not give this man a fair trial when he absolutely deserves one. It's absolutely insane. Luigi Mangione deserves a fair case like everyone else, and trying so hard not to give it to him. I don't know, because a pride thing, I guess, at this moment in time. It's insane how much they're like trying to scramble for like anything and everything to pin against Luigi Mangione, but then it's like, it doesn't make sense. Why are you guys trying so hard when you're certain you caught the right guy? Sorry, this is a little bit scrambled and not as structured like all my other videos I've made over the last year or so, almost year in this moment in time. I will celebrate this channel's birthday. I'll buy a cupcake or something, or a cake. Cakes are delicious. Hope you liked this video. I hope you found it useful, even if it's like 3 months late. Do apologize, life happens. I am human, there is no one else here. But yeah, thank you for watching this week's video. You can subscribe if you want to, it's okay if not. I upload 3 times a month, and if you guys want to keep up to date with the channel, you can follow the channel's social medias, that'll be in the description down below. And if you guys want to follow me personally, my social media is in the description down below. And yeah, thank you for watching this week's video. Bye!